Okay. Good morning, everyone. Good morning. Welcome to the Great Hall. This is a beautiful room. Our assembly looks a little different than it has in the past, but this is a room that has the flags of every community of our Commonwealth, and it's a beautiful room in a setting for our assembly today. I am opening our assembly on behalf of the members of the Governor's Council. Welcome to all of you. And I, of course, want to welcome Justice Budd and her family, her husband, William, her father, Wayne, her godfather, former Attorney General Tom Riley is here, and friends and distinguished guests that are both here and in person. We can see you, Councilor Hurley, on our screen. Thank you. And you can see the technology involved in having this virtual assembly today. We are also honored to welcome Chief Justice Roderick Island, Geraldine Hines, and current Supreme Judicial Court members, Associate Justices Lank, Gaziano, Lowy, Seifer, and Kafka. Thank you all for being here today. I would now like to recognize Governor Baker, who will introduce our nominee.
Thanks very much, Lieutenant Governor. And let me just start, first of all, by saying that I think we all know that the events of today were determined as a result of a tragic circumstance involving Chief Justice Ralph Gants. I think for everybody involved, that was a shock and an enormous and hugely upsetting surprise. But it's very important that the work of this particular court, the oldest continually operating court of its kind in the United States, continue. And shortly after his passing, we began a process to find a nominee who could step into that role and continue to bring the professionalism, the kindness, the grace, and the decency and the humility that Ralph and his predecessors have always brought to that role. And after a series of interviews with a special judicial nominating commission that was set up by the administration, several nominees were sent to the Lieutenant Governor and me to be interviewed. We conducted those interviews, reviewed the due diligence, and discussed this with our chief counsel and his team, Bob, and his team, and decided that Associate Justice Kim Budd would be a worthy and superior choice to succeed Justice Gants in the role of chief. And we very much appreciate, no matter where the setting is, the thoroughness and the respect that you all have shown to every nominee that we've brought before this council over the course of the past 5 years. And you have been especially gracious with the folks we've brought before you to sit on the SJC. We think that Associate Justice Budd is absolutely the right candidate for this moment, based on her experience, and frankly, based on, as I said when we announced this nomination, her skills as a collaborator, a listener, and a leader. And in this time especially, those skills are of utmost importance, not just here in Massachusetts, but around the country, and I would argue in some respects around the world. I believe, and I know the Lieutenant Governor does as well, that she will make us all enormously proud if you choose to affirm this nomination. And I look forward to the hearing. And with that, I'm going to turn it over to the Associate Justice and to all of you and to the Lieutenant Governor. Thank you.
Thank you, Governor. I share your enthusiasm for Justice Budd, and obviously members of our council will have time today and for whatever time it takes to evaluate her experience and her credentials and her skills for the position of Chief Justice. Thank you for acknowledging Chief Justice Gant's contributions to our Commonwealth, and we look forward to hearing from Justice Budd today. But I have to go over a few rules. I don't know if, Governor, you want to stay and listen to more COVID protocol rules, or you feel you'd like to go on, but we're going to go over the rules.
I should probably leave. Since we had something to do with writing most of them. If you don't like them, I'd rather not be here for that. Again, I very much appreciate your willingness and your flexibility with the calendar to make this happen. Thank you very much.
Okay. Thank you, Governor. All right, so we all noticed that this is a little different. We have people that are seeing this through our live stream technology. We have counselors in person and virtually, and the rules are such that we have COVID to manage during this whole process today. I do want to stress that there is distance between us. Obviously, a lot of distance between us and the ceiling here, so a lot of good airflow. And we have the ability to interact with face coverings and other protections for all of us here today. I do want to express that all those who have expressed an interest, both the organized witnesses by Justice Budd and others who wish to participate in this hearing, have the ability to do so, whether in person or remotely, despite the COVID protocols. This is, as I said, live streamed via YouTube, allowing many in the public to witness this hearing and this moment in our Commonwealth. I would also like to note that no one is allowed to bring food or drink into this hearing. Otherwise, Dean Serper, who was right there, will be tapping you on the shoulder. I would just want to acknowledge Dean and your team. You did a really wonderful job today. Thank you. That while in the room, all must wear a face covering except when speaking. And please avoid gathering in small groups during and after the meeting. So I guess the message of the day is let's work together, let's be efficient with our time, and allow this hearing to take place safely for everybody. Justice Budd, as I mentioned, has already submitted a witness list of 4 people who will be speaking on her behalf to members of the council. 3 of the witnesses are here in person and 1 is participating remotely. I do want to state that everyone, as I said, will be heard relative to speak on behalf of or in opposition to the nominee, her qualifications, or to participate in this process with their testimony. Now, I'd like to introduce our counselors. And this hearing will be conducted in a very similar fashion that everyone here is familiar with in terms of our past SJC hearings. We have districts 1 through 8. District 1 is Councilor Joseph Ferreira. District 2 is Councilor Robert Jubenville. District 3 is Councilor Marilyn Petito Devaney and the host counselor for Justice Budd. We have Councilor Ianella from District 4, Councilor Eileen Duff from District 5. We have Councilor Terry Kennedy from District 6. We have a vacancy in District 7, and we have Councilor Mary Hurley from District 8, who is prominently displayed on our screen. What will happen today, just so everyone can organize their thoughts about their day. In a few minutes, we will read the governor's letter of nomination. I will ask Justice Budd to introduce her family. And then we will ask Justice Budd and any witnesses who wish to testify, both those who are in this room and those who are participating remotely, to take an oath. And then we will ask Justice Budd to deliver her opening statement. After that, questions from the counselors will begin, and they will begin and be led by Counselor Marilyn Petito Devaney as the lead counselor and the home district counselor for Justice Budd. There will be a break this afternoon around 1:30, 1:45, and that break will continue until about 3, and a little after that, we will reconvene. And of course, we will take a break, just a short break, mid-morning, about 5-10 minutes for people to stretch their legs and do other things. All right, so dated October 28, 2020, this is a letter to the Governor's Council. Dear counselors, I am pleased to nominate Kimberly S. Budd to the position of Chief Justice of the Supreme Judicial Court. I submit this nomination for the advice and consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of our Commonwealth of Massachusetts. I am enclosing the nominee's resume for your convenience. Sincerely, Charles D. Baker. Justice Budd, could you please introduce your family this morning?
Thank you. I would love to. Here with me today is my husband, Bill Thompson. Next to him is my father, Wayne Budd. Next to him is my oldest son, Will Thompson. And next to him is my niece, Olivia Budd Pearson.
All right, so at this point, all those who are testifying today, both those who are in person and those who are participating remotely, please stand to take the oath. And Justice Budd. Okay. All right, please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
I do.
I do. Thank you. All right, we will now hear from our first witness. It is an honor to have the Honorable Roderick Island here this morning to speak on behalf of Justice Budd. It's a pleasure to have you. Thank you.
Thank you. Lieutenant Governor Polito, members of the Governor's Executive Council, members of the legislature, of the judiciary, and of the executive branch, ladies and gentlemen. My name is Roderick Ireland, and I have the high honor of speaking on behalf of Kimberly S. Budd's nomination to be Chief Justice of the Massachusetts Supreme Judicial Court. In my estimation, Kim Budd is extremely well qualified to serve as Chief Justice of our state's highest court. She is smart, experienced, seasoned, analytical, a great listener, open to hearing all points of view, patient, humble, and on top of everything else, is a kind and decent person. She will represent all of the citizens of our state in a fair and responsible way, and in doing so, will reflect favorably on all of us. As one who has appeared before you 4 times, I think that I fully understand how seriously you take your responsibility to see that only the most qualified candidates are confirmed to the Massachusetts judiciary. In my estimation, Kimberly Budd meets your very high standards. In addition, as one who has served on the Supreme Judicial Court for 17 years, including 4 as Chief Justice, I believe that I have a very good sense of what it takes to succeed in that position. And again, in my estimation, Kimberly Budd has what it takes in every respect and will be an outstanding Chief Justice. I believe that Kim will manage all of the many duties and responsibilities and administrative chores of being the Chief Justice, including representing the third branch with the executive and legislative branches in a disciplined, unbiased, and reasoned manner. She will engage with her colleagues with an open mind. She will study and apply established precedents to arrive at the correct resolution under the law. And she will draw upon her knowledge and life experience to bring human understanding to the consideration of those matters. Kim Budd will lead by example, and in doing so, she will represent the court and serve the citizens of the Commonwealth in a very positive way. The SJC is a very special bench with outstanding justices and a brilliant staff, and it deals with some of the most challenging and difficult cases which impact on all of the citizens of this great Commonwealth. And in these unusual times we live in, the SJC will need a special leader. And that special leader is Kimberly Budd. She can and will do an outstanding job. I respectfully ask and urge you to confirm the nomination of Kimberly Budd as Chief Justice of the Massachusetts Supreme Judicial Court. I do so sincerely and without reservation, and recommend her as an extremely well-qualified nominee in every respect, fully deserving of your positive vote. Based upon my experience at the court, I know that Kim will make us all proud. Thank you.
Thank you, Chief, for your testimony and your experience as Chief, and speaking to this moment and to this nominee is particularly compelling. And we appreciate your presence and your words today. I ask my fellow council members, are there any questions for the Chief? Yes, Councilor Iannella.
I don't have any questions, just a statement. You alluded to the fact that you've been before this body on 4 different occasions. And I want to say I was fortunate enough and proud enough to support you on all 4 occasions. Good to see you again.
Thank you so much, Counselor.
Councilor Cubanville.
Judge, and thank you for your service. I can take this off, I think, when I'm talking. Thank you for your service. And I also want to thank you for what I see the top signer of a letter from the Ad Hoc Committee for Judicial Independence regarding a judge that was placed under arrest.
Yes.
Or charges were filed against her. It was a great letter. I'm going to get into a little bit of it later, but I thank you for signing that, and hopefully we can rectify that situation in some way. The other question I have for you is, I believe you had some pretty good success when you were the Chief Justice in this building, convincing the legislature to open up the purse strings for the court system. And in my opinion, that is part and parcel to being a chief, is to be able to come over here and get that done. How do you think that should be handled with the new chief coming in?
Well, I'm sure if Kim becomes the chief, that she will reach out to both the executive and legislative branches. It's important that the 3 branches work together. Our system requires working together, and we can't just operate as a silo without engaging with the other 2 branches. I'm sure she will do that.
I'm told that the legislature appropriates in the budget about 1.5% of the state budget to the judiciary system. Being 1/3 branch of government, obviously you know and I know that is a paltry sum.
Yes, it is.
Do you think the the judiciary should have a lobbyist of its own helping the chief judge over here.
Well, back when I was the chief, I thought of myself as the lobbyist for the courts.
Maybe you should come back as a lobbyist now. We need you back. We got to get up to 2 or 3% at least.
Well, they need to be educated about all of the different activities and responsibilities that the courts are asked to do. I think most citizens take courts for granted, and there is not a spokesperson for the court system.
Right.
And that's why I think part of the chief's responsibilities is to engage with the other two branches.
Thank you, Judge. And again, thanks for coming.
You're
Appreciate
welcome.
your remarks.
Thank you.
Counselor Devaney?
So good to see you today.
Yes, ma'am.
I also wanted to vote for you before, and I have to say that I regret that we couldn't have got you earlier, because when you were appointed, we only had you a little over 2 years. But I want to tell you, I'm working to change that 70 years. I mean, if you can be a recalled judge at 75, it makes no sense to me that you had this mandate to retire at 70. We've lost so many good people like you and Justice Hines and Justice Link. But I do want to follow up to thank you for when you were Chief Justice to work with the legislators to get more money. And as it's been said, it's still not enough. I keep asking for funding for drug treatment centers.
Yes.
And so I hope that Justice Budd will do her best to work on that. We don't have enough, that. We probably have 3, and there's only 1 for women. So, we've got to do something about that. But, the only question I would have to you is, looking back, serving with Justice Budd, what particular decision was before you that you were so impressed with Justice Budd?
Well, we didn't actually sit together. So
I know that.
I can't really comment on a case that we sat together on,
Yeah.
but I know she has written some outstanding opinions as an associate justice at the Supreme Judicial Court. And I'll let her talk about her opinions.
Right.
But she's been really very impressive with her opinions.
Right. Well, I miss you, and I wish you continued health, you and your wife, and
Thank you.
and congratulations on having that courthouse named. So rightfully so.
Thank you very much. Thank you.
Other members of the council? Counselor Hurley? Yes.
Yes. Good morning,
Morning.
Your Honor. Pleasure to see you again. And I really don't have any questions. I just want to point out to the public that you are a Springfield boy who made it big in the Golden East. And the courthouse that was referred to is the courthouse in Springfield, Massachusetts, the Hampden County Hall of Justice, that's now named for you, deservedly so. And I would be remiss if I didn't also point out that Wayne Budd also came from Springfield. His father was a very well-known, very well-respected captain on the Springfield Police Department. And both of your families have done the city of Springfield proud. And I'm proud to be a member of the population of Springfield that's gotten to see you two really rise to the top. And I think Kimberly Budd is nothing less than the top of the crop as well. So thank you very much for being here today.
Thank you, Counselor. I will just say that Wayne and I both attended the same elementary school, although he was several years older than me, so he was a little older, and us younger kids always looked up to him as a role model.
What school was that?
The William N. DeBerry Elementary School.
Okay, and when I was mayor, we now have the Rebecca Johnson School.
Yes, she was our principal.
Absolutely. And she's the one that got you guys to get in line, I'm sure.
She sure did. Sure did.
Thank you.
Well, thank you, Councilor Hurley. I am glad that the principal got some recognition for the contributions the Ireland and Bud families have made. And I'm not surprised, Councilor Hurley, you would express how proud Springfield and Western Mass is relative to these two families. So thank you. I think that is it for you, Chief Ireland. Really appreciate your being with
My
us.
pleasure. Thank you all.
Thank you, and to see you so well. We will now ask the Honorable Geraldine Hines to present her testimony, and she will be participating by virtual means this morning.
Good morning.
Justice Hines.
Good morning. Lieutenant
Good
Governor
morning.
Polito and members of the Governor's Council, I consider it a high honor and privilege to appear before you today to support the nomination of Kimberly S. Budd to Chief Justice of the Supreme Judicial Court. When I started my legal career almost 50 years ago, at a time when the country was in the midst of its awakening from the nightmare of Jim Crow that had colored my own life experience, I could not have imagined a moment such as this. A Black woman being nominated as Chief Justice of the Supreme Judicial Court, the oldest continuously functioning appellate court in the Americas. So I want to express my profound gratitude for the privilege of bearing witness to this historic moment and for the opportunity to appear before this body to express my views about the merits of this historic nomination. First, I join others across the Commonwealth in congratulating the governor for bringing this nomination to you, breaking through the barriers that held us back from this moment for 328 years, the time since the founding of the court in 1692. That is a long time to wait for a woman of color to take her seat at the head of the table. But people of goodwill and the legal community and beyond applaud you, Governor Baker and Lieutenant Governor Polito, for using your wisdom and authority to end the long-running historical void. You deserve the universal respect and praise that have followed from your decision to select Justice Budd for the honor of joining the 3 other women of color in the country from California, Louisiana, and North Carolina, who now serve as Chief Justices of a state Supreme Court. I am here today to urge the Council to validate the Governor's historic choice by confirming Justice Budd as Chief Justice of the Supreme Judicial Court. Though we rightly recognize and pay homage to the historical significance of the moment we are experiencing right now, we should not tarry too long on the subject because the virtue of this nomination transcends history. Beyond the history, I urge your confirmation of Justice Budd because in my humble opinion, she is quite simply the best person for the job. She is unquestionably well qualified and well suited to the task of leading the Massachusetts court system because of who she is and what she brings to the task. I have known Justice Budd as a colleague on both the Superior Court and the Supreme Judicial Court, and I can say without fear of contradiction that she will bring a prodigious intellect, an enviable work ethic, an honest humility, a youthful vigor, a quality that, in my humble opinion, is highly underrated, and most importantly, a passion for justice to the task of being Chief Justice. I know that she cares deeply about the reputation and standing of the Supreme Judicial Court, among the most respected appellate courts in our country, and she will be vigilant in making sure that it remains intact. From my own experience, the collegiality among the justices, even when there is a difference of opinion about how a particular case should be decided, is essential. Justice Budd is the kind of person who will enable that and will do her part to ensure that it continues. Her record as a justice demonstrates that she has brought her considerable legal acumen to some of the most difficult issues facing the court. In all of her work, she has shown herself to be a brilliant and fair-minded jurist who, at a time when our country and the Commonwealth face a reckoning on social justice, systemic racism, and the vitality of the rule of law, is ready to lead our courts in playing the role that courts must play. I can think of no one better than Justice Budd, with her steady hand and firm resolve to lead the court during such a time. Justice Budd is aware, as we all are, of the sad circumstances that open up this opportunity for her to walk in the path charted by the beloved Chief Justice Gants. His shoes will be hard to fill, but I have confidence that she stands ready to carry forward his legacy, working within the law to advance the cause of equal justice and to bring to bear her own vision of how the courts can best serve the people of the Commonwealth. Later today, when Justice Budd has the opportunity to speak for herself, she will tell you about what she hopes to accomplish and how she will manage the enormous challenges that she will face as Chief Justice if she is confirmed. Having known her as a friend and colleague for more than a decade, I can say to you that whatever she tells you will come as the result of her deep reflection on what this moment demands of the next Chief Justice and whether she believes she can meet those demands. And I can reassure you that her quest to become Chief Justice is not born of any need for personal gratification or public favor. She presents herself to be measured by your consideration because in her discernment of the challenge, she believes and has confidence that she can meet the test. On a personal note, I regard Justice Budd as a valued friend because she is a genuinely decent and caring human being. In your consideration, I urge you not to discount the value of this quality. Of course, wisdom and good judgment are essential, but the value of humanity, the ability to imagine and have concern for the real people behind the court's decisions, should not be underestimated. I've been privileged to serve on one of the most highly regarded and respected appellate courts in the country, and from that vantage point, I can say with unwavering confidence that Justice Budd is worthy of being confirmed as the Chief Justice of the Supreme Judicial Court, and I urge you to do so. Thank you for this opportunity to speak on her behalf.
Thank you, Justice Hines. Your words were beautiful, and the reference to youthful vigor was welcomed in this room for sure. Thank you. It's great to see you doing so well. Members of the council, questions? Councilor Devaney?
So good to see you. So many good memories. You made me cry, okay? But so I'm sending you a virtual hug, okay? But I admire you so much because you are the role model why Justice Budd is here. And you've been such a mentor. But she has emulated all of the qualities that you have. And what a wonderful mentor. And it is wonderful what you said, how the congeniality of all of the justices. I couldn't be more pleased with every one of them. And I have voted for them, really with my heart. So what I just want to say about you is that you are such a role model, a leader, when we think of coming from where you came from. It's the American dream. You lived through the Jim Crow days. And I am so honored to be called your friend. Almost 20 years in January. I'm going to cry. And so I voted for you 3 times. And my biggest regret was we only had you 5 years. And I remember when I voted, I said, we'll only have Justice Hines 5 years, but it'll be the best 5 years that Massachusetts ever had. Thank you so much. Now, I want you to tell me, this is a little difficult, one quality, if you can think of one, that Justice Budd brings as Chief Justice.
Well, I mentioned a lot of them, and all of them are important. But I think that her humility blended with her brilliance is what's going to make her a wonderful Chief Justice. Sometimes I think of her as being an iron fist in a velvet glove. I mean, she has that capacity, but I don't want to scare anybody by saying that. So I didn't put that in the remarks, but that's what she is.
Right.
So that's what she'll bring to the task.
Well, thank you so much. Stay safe. Thank you.
Councilor Jubinville.
It's good to see you, Judge.
Thank you.
I also want to thank you for signing the letter that I mentioned a little earlier regarding the Committee for Judicial Independence on the overreach of the United States Attorney's Office against one of our sitting judges. I appreciate you signing that letter.
Thank you.
So you've done great work on the courts you sat on, but would really like to have you back in the Superior Court where
No
you
way.
were just so kind to our citizens of the Commonwealth. We're going to present a petition to the newly established Chief Judge to recall you to the Superior Court.
That's one offer I have to refuse. I'm sorry.
You can't. It's against the law to refuse. You'll have to come back. We miss you.
Thank you.
Okay, any other counselors wish to comment or question? Counselor Hurley? Okay. Justice Hines, thank you so much for your presence here today. It was really great to see you.
Thank you. I appreciate
Thank you.
it. Thank you.
Our next witness is Mr. Gerald Howland. Good morning.
Good morning, and good morning all. It is a wonderful honor to be here this morning to speak on behalf of Kim Budd's nomination to be Chief Justice of the Supreme Judicial Court of Massachusetts. I am listed in the program as Attorney Jerry Howland, but I'm here to speak as an educator about my experience with Kim Judd and to maybe give some evidence to support Justice Hines's comments about Kim Budd's humanity and her contention that it may be the most important quality of a Chief Justice. Again, my name is Jerry Howland, and this is my 51st year as an educator in the Boston Public Schools, where I've served as a teacher, coach, and administrator. Currently, I am the interim head of school at Boston Latin Academy, one of the city's exam schools. And I first met Kim Budd about 17 years ago when we both served on the Judicial Nominating Commission. And it was during that time that Kim, I, and 18 others met 4 or 5 hours on Tuesday nights, read tons of applications, interviewed people, did due diligence, volunteered an enormous amount of hours to find the right people to put the names before the governor of Massachusetts for the judiciary. And I think even though Kim was the youngest person on that committee, she distinguished herself with the quality of her contributions to the conversations. And with all the rest of us, her commitment to spending that enormous amount of time to make sure the right people get before the governor. But my next connection to Kim Budd is my main purpose for being here today. For the past 27 years, I have served as the educational director of the Judicial Youth Corps. It's a summer internship program for Boston students sponsored by the Supreme Judicial Court. And the JYC was created in 1990 by then Chief Justice Paul Liakos, who wanted Boston kids who did not have parents who were lawyers or judges to get an opportunity to have the same kind of internships in the courts that those who did. And his goal was to expose Boston students to the wide range of careers in the legal system in an effort to inspire students from underrepresented groups into joining the legal profession. I should note that Justice Liakos at that time, after he created the program, recruited a young juvenile court judge, Roderick Ireland, to oversee the program. And he has been involved in this program for every single one of its 30 years and continues today. The 20 students in the JYC represent the demographics of the Boston public schools, where at the high school level, over 90% are students of color. During the summer, the students work in various court offices in the Suffolk County, and my job is to create the educational activities that reinforce what they learn on the job. We visit jails, the Boston Police Department CSI units, and do major mock trials and other activities. But the most powerful education experience for the students over the past 7 years has been provided by Kim Budd. One of the things I do as part of the education, I find opportunities for students to observe real trials, to teach them the difference between what they see on TV and what happens in real life in the pursuit of justice. When Kim was a trial judge sitting in Suffolk Superior Court, I arranged for the JYC interns to sneak out of work on a regular basis to see her in operation, in presiding over felony cases. They were in awe of her ability to be in total control of the courtroom while treating everyone with the utmost of sincere respect, even contentious attorneys who tried to overstep their bounds, but not for long. I think that's a reference to the iron, the velvet glove, and I think there was more velvet than iron in that. And it was a powerful experience for the Boston students. The heartfelt things they told me afterwards demonstrated the profound effect it had upon them, seeing Kim Budd do what she did. The highlight of the summer for almost all the interns was their opportunity to have lunch with Kim Budd. It was a tradition started by Roderick Ireland. 4 times a summer, Kim hosted a lunch for the JYC interns, 5 or 6 students at a time, so she could get to meet them personally. She talked about her career path starting from her high school days, college days, the struggles for her, and then answered all their questions, personal and legal. Kim found a way to genuinely connect with each student at the table, asking them questions and getting to know them personally. During my debrief sessions with the students afterwards, they expressed their awe at what she has been able to accomplish, but their equal amazement at the fact that she is a real person, not very different than they, and even though they may be facing more challenges in the path, Kim left them with the feeling that they can do what she has done. As an educator, I can tell you that there is no greater accomplishment for an educator to get students to that feeling. And after many, many years in education, I have learned that all I need to do to get there is to bring my students to have lunch with Kim Budd. Justice Ireland referenced the quality of Justice Budd's decisions that she writes. I can't testify to that, but I can testify that several years ago, I was working with the Marshall Brennan program. It's a national program for competition for students who argue Supreme Court type cases. And it's from students from underrepresented communities. And it's a national program, and they were having their national trial here in Boston at the federal court. And when I asked Kim Budd, she agreed immediately to be the presiding justice over the championship trial. And the thing I want to note about it, though, beyond the same thing she does always to volunteer whenever it's on behalf of students, is that I picked her up when I picked her up to take her to the trial, but I picked her up at the John Adams Courthouse and brought her back to the John Adams Courthouse after the trial. But I should note that it was on a Sunday. So I guess one of the reasons she writes those decisions is spending that amount of time on a Sunday. And that fact that she broke that up to volunteer on behalf of students nationwide was, again, a tribute to her humanity. If we were not in the middle of a pandemic, I could have filled Gardner Auditorium with Boston students whose lives Kim Budd has touched. And I will leave you with the words of one of them, Kamani James, a senior at Ladd Academy, who's now the student rep on the Boston School Committee. He spoke at this year's graduation ceremony for the JYC. And because of the courts were closed, we ran the JYC virtually on Zoom. So I was able to go back last night, get the videotape of the graduation ceremony and get his exact quote. Because he was chosen to be the graduation speaker. And the main part of his message was attributed to, it was in honor of Kim Budd. And his choice of words reflects what all members of the JYC feel about Kim Budd. He said, quote, "Kim Budd radiates hope, determination, and passion. The fact that a woman who looks like us moves with such grace in a position of power is an inspiration to all of us." Now, I have had the great fortune to work directly each summer for almost the past 30 years with an incredible string of Chief Justices, and it's a great tribute to the state of Massachusetts. I worked with Chief Justice Paul Liakos, Chief Justice Herbert Wilkins, Chief Justice Margaret Marshall, Chief Justice Roderick Ireland, and Chief Justice Ralph Gantz, who was in attendance at that meeting I just referenced. And the JY students were devastated less than 2 weeks later when they learned that he had died, because he had that same kind of humanity and connection to the students that Kim Budd does. And every single one of those people I just mentioned is not only a great legal person, but you can comment on their humanity. So my opinion, based on my firsthand experiences, and not just the hearsay testimony of my students, is that Kim Budd is the same quality person, has the same humanity that belongs next in that incredible line of Chief Justices. Thank you.
Thank you, Mr. Howland, for elaborating on the JYC program and the ability to incentivize or inspire youth of our Commonwealth to pursue positions in our justice system, which are so needed. Thank you for your contributions to the organization. I can see that you're quite proud of your work there. Members of the council, Councilor Jubinville.
Briefly, I thank you for coming in here. That was a great presentation. And I really thank you for that. And as an aside, I want to compliment you on your choice of hair coloring. Great.
Thank you.
You'll have to compare your shoes. That's another topic. Councilor Devaney?
I just want to thank you for all you do. It's an education for me. I didn't know about the organization and what you've done, and what a tribute to Justice Budd. And, it just shows how, she is so giving, and to be involved with the students and everything. I just think it's great. Thank you for what you do.
Thank you.
Okay. Thank you very much, Mr. Howland. The next witness is Miss Mary Sheridan. Ms. Sheridan is a former law clerk and will speak to the counselors next. Welcome.
Good morning.
Good morning.
Lieutenant Governor Polito, ladies and gentlemen of the Governor's Council. My name is Mary Sheehan. I reside in South Boston, Massachusetts, and I am here today to give my wholehearted and enthusiastic approval of Justice Budd's confirmation to Chief Justice of the Supreme Judicial Court. I'd like to give just a quick plug to the Marshall Brennan program that Attorney Holland mentioned. I myself was a participant, and so highly recommend it to any law students. I sat here before you 4 years ago in early August of 2016 during what was then Judge Budd's confirmation hearing to Associate Justice of the Supreme Judicial Court. I reflected on my experiences as an intern for Justice Budd during my first year of law school and how she had an immeasurable impact on my legal thinking and my thoughts on the court system. Now, 4 years later, 2 clerkships, one of which was with the justice, and a year under my belt at a law firm, I can reaffirm that Justice Budd's presence and mentorship throughout the years has remained the biggest impact on both my career and my personal life. There are more than a few memorable experiences that I can draw on to emphasize this, but I'll resort to telling just a few today. The first of which I'll pull all the way from when I started as her intern in the summer of 2015. It was my first day, and I came bopping into her courtroom in Middlesex Superior Court, full of excitement. Court was still in session, so I took a seat in the gallery. Her courtroom officer, Teresa, immediately summoned me over to sit next to her. She said to me, "You must be Mary. You're going to have the best summer. We all love Judge Budd." I learned over the course of that summer how special Judge Budd really is, and how much the court officers, the courtroom clerks, and the rest of the staff truly loved her. It was because she saw them not as just employees of the court, but as her equals, her team members in carrying out justice. My own thoughts of the judge were shaped during a lunch over tacos early that summer. We sat down to eat, and I confessed that I was nervous. She looked me in my eyes and said, "Why are you nervous? I'm a person just like you." Ever since I've known her, she's never lost that humility. Fast forward a few years, I'm one of 2 of her law clerks during the 2018-2019 court term. It was an honor to clerk for her with my co-clerk, David Kim. As her law clerks, we spent many hours talking through opinions, lengthy trial court records, and case precedent. I will admit that it's hard at first receiving a draft opinion back from the justice and seeing it covered in red, but you quickly learn that it's not about you. It's about getting the opinion right and making it better each time it's reviewed. This is something the justice has, in my eyes, mastered. One part of this process that stayed with me is the justice's ability to relate to the trial court judge and put herself in that judge's shoes when making the decision. She understands how difficult it is as a trial court judge to make quick but reasoned decisions during trials and hearings. She equally understands the importance of making sure that the parties receive justice under the law and a decision that the parties can read with ease and clarity. Her ability to balance these things will make her success as Chief Justice come naturally. I'm not the only one with positive experiences with the justice, as you've heard from 3 other witnesses today, and I'd like to highlight a few of the many other people who she has made an impact on. My co-clerk, David Kim, writes, "I cannot say enough in support of Justice Budd's nomination to this position. When I began my clerkship, fresh out of law school, I didn't know quite what to expect. I didn't know that Justice Budd would be more than just a boss, that she would become such an important teacher, mentor, and friend. She was always there to offer extremely detailed and prompt feedback on our work and to push us to be ever sharper thinkers and writers. Whenever I went through a challenge in my personal life, she knew exactly when to give space and when to offer sage advice. She has supported us in our professional aspirations and has never hesitated to provide a helping hand however she could. I now could not imagine my life without her influence, just as I could not imagine the Supreme Judicial Court without her presence. And it gives me a great deal of hope for the Commonwealth and our country that she could be our next Chief Justice. Devin Braun, a former law clerk to Justice Link, writes, "Justice Budd played a monumental role in shaping one of the best years of my life and career. That was my Supreme Judicial Court clerkship. Besides being a brilliant jurist, she was always open to sharing the specifics of her career path, giving advice on the many diverse avenues and timelines available for women in the law. Justice Budd reminded us as attorneys to always ask the hard questions and to truly hear the answer. Whether intentional or not, Justice Budd has been a mentor to me, and I'm sure to all who have had the absolute honor of meeting her." Marina Polaritz, a former law clerk to the late Chief Justice Gantz, writes, "It's impossible to reflect on my time at the Supreme Judicial Court without thinking of Justice Budd. One memory of many comes to mind. I was working through a case with one of Justice Budd's law clerks and came by the law clerk's desk to talk through a particularly thorny problem. A few minutes in, the law clerk said, "We should have the judge weigh in." I walked into Justice Budd's office for the first time feeling nervous and woefully underprepared, and walked out knowing, even more than I had before, that the Commonwealth was incredibly fortunate to have Justice Budd on the bench. Justice Budd listened to the arguments and to our thoughts on them with care and focus, valuing our opinions despite being infinitely more knowledgeable on the law. I was struck by her ability to see through the nitpicky details that had bogged me down. The Commonwealth needs judges who listen, who care, and who understand the real-life impacts of our justice system. I have absolutely no doubt that Justice Budd is such a judge and would be such a chief. Michael Turi, former law clerk to the late Chief Justice Gantz, writes, "I appreciated that she was a constant presence in the courthouse and always made herself available to talk to the clerks and court staff alike. I know that, as a conscientious listener and strong ambassador for the court's work, she is the best choice to carry on Chief Justice Gantz's many projects and maintain his legacy of promoting equal access to justice for all." While I'm physically speaking directly to the body presiding over this hearing, I'd like to think that this hearing is in large part for the public's benefit. A process in which the people of the Commonwealth get a glimpse into what the nominee is like, what her governance over the courts might entail, and whether she is someone they can see themselves in. It is not unreasonable to think that the people want someone who is not only qualified to take the most powerful seat in the Massachusetts judicial branch, but also someone who understands their experiences in and outside of the courtroom, who can relate to the struggles that different groups of us face every day, and who can inspire and connect with the younger generations of the Commonwealth. Let me assure you, Kimberly Budd brings more than just her experiences as a trial court judge and an associate justice of the Supreme Judicial Court. She brings with her the experiences of a mom raising 2 young boys and working a full-time job, a Black woman who faces the harsh realities of living in a country which is plagued with systemic racism. She also brings with her the experiences born from the titles wife, daughter, sister, daughter-in-law, friend, colleague, boss, and mentor. She is a person that makes me and countless others proud to be a lawyer, a woman, and a citizen of this Commonwealth. I know the job she endeavors to take is not an easy one and will bear great weight on her shoulders, but behind her follows a support system as large and as strong as they come. And although he is no longer with us, all of us who knew him closely know that the late Chief Justice Ralph Gantz would be sitting right behind Justice Budd with his full support and confidence in her ability to succeed as the next Chief Justice of the Supreme Judicial Court. Justice Budd is tuned into the issues that the courts and the community at large are facing. She's prepared and capable, and she is ready to take on the role of the Chief Justiceship of the Supreme Judicial Court. Thank you.
Thank you, Attorney Sheridan. It was very well stated. Thank you for speaking to the power of role models and mentorships. And obviously, this one proved to be very important to you. It's made you a better lawyer and a better person. Thank you. I love your reference to seeing yourself in a position, and what an inspiration both Justice Budd and you serve as a role model to others who might like to see themselves in a position within our judiciary or as an attorney, and the power of holding any of those role titles or having those roles possesses. So thank you very much for your words of inspiration today as a young leader in our Commonwealth. Councilor Devaney.
I have no words. That was beautiful. It was a beautiful presentation. And what a wonderful tribute to Judge Budd and Judge Ralph Gantz. I'm sure he's looking down, smiling.
Thank you.
Thank you.
Yes, Councilor Kennedy.
That was a great tribute. Really appreciate that. Appreciated the reference to women in the law, being brought up well. And I know it's still difficult for women out there practicing. practicing in this day and age. I just want to leave you with one comment. I hope I'm still on the council when we're reviewing your application in a few years.
Thank you. Thank you.
I think Councilor Kennedy speaks for a lot of us sitting here. I think you also speak to the power of lunch in the interest of getting together around a table and having a casual opportunity to share. And apparently that has been a key part of Justice Budd's experience. Any other? Yes, Councilor Devaney?
No, this is the last witness.
There are other witnesses that would
Okay.
like to speak.
All right,
in
good.
favor?
Okay, no, that's okay.
Okay.
All set.
All right.
I don't know the time to say, but I just wanted to make sure that people know this is quite different, this hearing that we're having. And I want people to know that there was a lot of adjustments to make. Justice Budd has been honored to attend the memorial for Justice Abrams today at 2:00. And so trying to juggle all these things, it seemed best to that we would recess at 1:30 to allow Justice Budd to have lunch, and then to go to the memorial at 2. So then everyone will be able to have that lunchtime from 1:30 to 3, and then we will resume. The other thing is that for people here at 12:00, we'll take a 10-minute restroom break. So, we had to juggle this, and I think it'll work out well. And thank you, Justice Budd, for being so gracious and going along with this schedule. Thank you.
Thank you. I'm not sure we'll make it to noontime, but we'll see. Thank you so much, Attorney Sheridan.
Thank you.
Continued success and satisfaction in your career.
Thank you.
There are others that would like to also testify in favor of Justice Budd today, and they are participating remotely. I see you on our screen. We have Supreme Judicial Justice, Court Justice Cipher, as well as Justice Lank. We will begin with Justice Cipher.
I'm on the spot.
Oh,
They came just in order to support me.
okay.
Oh,
So-
no, I'm happy to talk.
I ensured them that they would not be talking, that they would just have to watch. So,
But I'm happy to support you and say everything every other speaker said is true. We're behind you, and we love you.
Okay. Thank you. But well stated. Thank you. Okay, and thank you, Justice Lang, for being present today for Justice Budd. We did receive a number of letters in support of Justice Budd's nomination, and let me just state them. Lawrence DeCara, the Honorable Susan Delvecchio, Attorney Stephen Wright of the Federal Reserve, Attorney Jonathan Cheel, a letter of support from the Massachusetts Black Judges Conference, and a letter from her former law clerks. And we heard from one very special one today. These letters all praise Justice Budd as a well-rounded jurist whose experience both on and off the bench have prepared her for this moment. They highlight her intellect, attention to detail, thoroughness, discipline, and ability to grapple with difficult questions and reach consensus in contentious situations. She's noted to be a leader, not just for the judiciary, but beyond. And finally, as one letter stated, as the face of the court, she will inspire respect and confidence of every person in our Commonwealth that justice will be done in that court. And stating those words in this room where every community is represented is pretty powerful.
In addition to those letters,
Yes, Counsel.
I received a personal letter from Justice Gary Katzman, and he asked me if I would read it into the record. As you know, Judge Katzman is now in the United States Court of International Trade in New York. Dear Counselor Devaney, I hope that you are safe and well during this pandemic. As you know, before beginning service 4 years ago on my current court, a national Article III court, I was an Associate Justice of the Massachusetts Appeals Court for 12 years. I remain your constituent. 4 years ago, I had the opportunity to speak with you about Justice Kimberly S. Budd and to sing her praises upon the occasion of her nomination to serve as an Associate Justice of the Supreme Judicial Court. Today, I am pleased to write this letter in support of the nomination of Justice Budd to serve as Chief Justice of the Supreme Judicial Court. In my view, she would serve with the highest distinction. Justice Budd's life and career themselves make self-evident the powerful and compelling merits of her elevation. I offer respectfully some personal observations. I have known Justice Budd for some 30 years, dating from when I was a lecturer in Harvard Law School, teaching the government lawyer course in which she was enrolled. I remember her well. This was my first time teaching. After an introductory lecture on the very first day of class, I posed a question to the 70 or so assembled second and third year law students. There was total silence for what seemed to me an eternity, and actually 2 minutes or so. My heart was in my throat. A hand went up. It was Kim Budd, who answered that first question and answered it brilliantly, breaking the ice. Engaging participation by her classmates ensued. That, as I came to learn, is Kim Budd, a person who leads by example. She excelled in the course. I was so impressed with Kim's abilities that I encouraged her to apply for a clerkship, and indeed was pleased to write a letter on behalf of her application to the appeals court. Following her clerkship on the appeals court, she worked in private practice for a major law firm. I next encountered Kim when she joined the United States Attorney's Office as an assistant United States attorney, where we were colleagues. Kim stood out as an effective and fair prosecutor in both the trial and appellate court. She accepted my invitation to serve as a clinical instructor in the government lawyer course at Harvard Law School, inspiring the young law students who might seek to follow her example in public service. You are no doubt aware of Justice Budd's breadth of experience, including work in the counsel's office at Harvard University and as director of the Community Values Program at Harvard Business School. Beginning in 2009, she was a distinguished judge on the Massachusetts Superior Court, and indeed elevated to the position of regional administrative judge. Judge Budd established a reputation for great scholarship, real legal acumen, judgment, common sense, fairness, and humility. She treats everyone with respect and kindness. In my humble opinion, Kimberly Budd was a great trial judge throughout her 7 years in that role. During the last 4 years, as an Associate Justice of the Supreme Judicial Court, Justice Budd is widely known for the analytical power and clarity of her landmark opinions and for her fidelity to the principle that justice be done under the law. The opinions are written with sensitivity to the litigants and the lower court judges whose work is under review. All concerned come away with the satisfaction of knowing that their arguments have been thoroughly and respectfully considered. Justice Budd has spoken movingly about Chief Justice Gants in his unfinished work. The Supreme Judicial Court has been led by great Chief Justices. As the leader of the third branch of the government, Justice Budd will no doubt make her own mark and will champion with vigor, humanity, uncommon skill and imagination, the fair administration of justice for every person in the Commonwealth. With her unique skill set and talents, we can look forward to her impactful stewardship. Respectfully, I believe that Justice Budd's life and career have prepared her for this moment during these challenging times, and we, the citizens of the Commonwealth, can only be grateful for her willingness to serve. In my letter of recommendation of support of Kim's application for a judicial clerkship dated September 13th, 1990, so long ago, but yet like only yesterday, I closed as follows. Finally, I have come to know Kim Budd to be a person of the highest character and integrity, to be gifted with that rare and tangible quality known as judgment, an individual of conscious and conscientiousness who has already shown dedication to the public good. Kim Budd will be outstanding. Friday, on November 9th, 2020, it can be reported that the ensuing years, and as exemplified by her long career of service, Justice Budd has consistently personified those highest of ideals. We can all be grateful for her example. I am pleased to offer these thoughts to you and your colleagues on the council. Very truly yours, Gary S. Katzman, United States Judge. So for him, I'm putting this in so that we will have this on the record. So you can make copies of that for everyone.
Okay, we will do that. Thank you very much, Councilor Devaney. And there are other letters of support, and in I think 2 additional ones we'd like to make note of. Councilor Duff.
Thank you, and I won't belabor running my mouth about these, but there is, and I will have these all admitted into the record because I think they're important. One, just a statement from the Boston Bar Association, and then the Massachusetts Black Judges Conference issued a letter, which I think is very important and very compelling. And of course, I'll be frank, one of my heroes, former Chief Justice Margaret Marshall, wrote an absolutely stunningly beautiful letter of support, which I would be more than happy to share with you at some point. But I will give these to the Lieutenant Governor, and they will all be submitted into the record because I think they all carry a significant amount of weight and they're quite important. Thank you.
Thank you very much, Councilor Duff. We will circulate those and share them with Justice Budd. Is there anyone else that would like to speak in favor of our nominee today? Okay, we have received notice that there are 4 individuals who will be presenting in opposition. They are on WebEx. We will begin with Patrick McCabe.
My name is Patrick McCabe. I live in Hyde Park, Massachusetts. I've been an advocate for parents in probate matters, specifically around the issue of custody. I work with a lot of different groups. I work with Fathers, Fatherhood Coalition, National Parents Organization, Waldo Brothers. I spoke in favor of the nominee in 2016. I spoke in favor of the nominee after speaking with her regarding the issue of child custody and fit parents. I asked her if she knew of any reason why a fit parent should lose custody. It's kind of a softball question, and she agreed that in most situations they should not. We did talk about the case of removals. And in 2018, the SJC made a decision, Miller v. Miller, SJC 12298, which was a removal case where they acknowledged that both parents were capable and fit. But the lower court took custody away from one parent, used the honest standard to allow the removal, and that's the part that I'm speaking to, the loss of custody. And whether there was ever any need for the loss of custody to make that decision. And this has been discussed a lot with all the members of the SJC, specifically when they come in front of the Governor's Council. And as you read this decision, It seems more like a blueprint for promoting sole custody than actually dealing with the issue at hand. I reached out and I spoke with the lawyer who defended this case, Matthew Barak, and I asked him if, what was the issue here? Was it custody or removal? He said it was removal. He argued custody because of the Giannis case. And I asked him how would his client feel if they were allowed to do the removal, but shared custody remained. He said his client would have absolutely no problem with that decision. I spoke with the plaintiff lawyer, Elaine Epstein, and the whole reason for filing the appeal was because of the standard that was used. It wasn't clear that they would win, but it was clear that they felt that having custody taken away was wrong, that should be reversed. I asked her if her client would have felt better if they retained custody and the removal still happened, and she acknowledged that would be an improvement. She also let me know that her client was being advised to move, as often happens in removal cases. Once one parent is allowed to remove from the state, the other parent will follow. And this loss of custody, since it was going across country lines, was not going to help that removal. I don't know that it interfered with it in any way or not, but certainly the decision was not going to help that family at all. After speaking with both lawyers, it's clear neither lawyer was really pushing for loss of custody. They were pushing for removal, and that should have been the case that the SJC decided. On October 15th, at a continuing legal education class entitled How to Handle Child Removal Relocation, the issue of removal was discussed. And for those of us who know what's going on in the law, the Giannis case has been the guiding case for removal since 1985. In 2006, Mason and Coleman put both parents more on a equal balance. The latest case, Miller v. Miller, kind of pushes us back to Giannis case in all cases, kind of gets rid of the balanced approach of Mason v. Coleman. And as the panel in this continuing legal education course was discussing this, one of the probate judges pointed out that they felt very uncomfortable with this new standard. They recalled when they appeared before the Governor's Council how it was made clear to them that making one parent the winner and the other the loser looked bad to everybody. It did not look like justice was being done, and it was questionable whether it was that case is really based on good law. As you read the Miller case, nowhere do they explain why the different standard would result in a different outcome. Had both parties retained custody, would the removal have been allowed? The evidence given suggests that the removal could have been allowed, that no one needed to lose custody. And this is why I'm speaking today, because a capable and fit parent lost custody. I would speak against not just this nominee, but any member of that panel on that decision. I think it's one of the worst decisions I have ever read, and I think everyone had been spoken to about this issue before they had this case. And I don't know what more can be done to make clear to the SJC that taking custody away from capable and fit parents is not something that's demanded in our laws or what people want. I think if you speak with the newer judges of the probate, they understand how removal decisions can be made without either party losing custody. And I think the probate courts are going in a much more civil direction than what this Miller case is pushing them in. I think this Miller case is pushing us backwards. I highly object to it. And I think anybody involved with it, you really want to take a look at them and question them about child custody before you elevate them to anything. Thank you.
Okay. Thank you, Mr. McCabe. Yes, Council Ferreira has a question for you.
Thank you, Patrick. Thank you for coming here virtually today. As you know, the whole idea of a parent losing custody is near and dear to my heart. I was divorced 20 years ago, and one of the worst days of my life was when a probate judge was yelling at me and my soon-to-be ex-wife, saying that shared physical custody never works and it wasn't going to work for us. We proved him wrong. I have a 21, 27, and 29-year-old, well-adjusted, great 3 daughters, and it worked perfectly. I do I do respect the fact that you came here. I too got an email from a lawyer asking me to ask the nominee about removal. I read Miller. I have Miller with me today. It's written not by Justice Budd, but Justice Cipher, who's a learned person who I deeply respect on the SJC. And I have to tell you that although I agree with your stance that dads and moms should have shared physical custody at all times, all things being equal, that in this case, there were findings by the judge and upheld by the SJC that dad didn't object to. They looked at the fact that the child was from Uganda. The statute didn't apply because they had lived in the Commonwealth less than 5 years. They looked at the fact that the judge found that mom was the primary physical caretaker of the child. Dad frequently missed allotted time to him and never made it up. He traveled often. There was a real advantage to the mother who described that she was impoverished in the United States but had a real job opportunity in Germany. They found that the child had traveled back and forth to Germany many times, was fluent in German, and would have a real life advantage in Germany. I did read it with great care. I actually agree with Judge Gaziano and Judge Gant's concurring decision that perhaps it should be a single test of the best interest of the child and not just real advantage depending on who has shared physical custody of the child. So I respectfully, agree with your work and everything you've done for dads and moms to make sure that there's shared physical custody all along the way. I think we've come a long way in the last 20 years since I got divorced, thankfully. But in this case, I think the court saw it right. And I'm just throwing that back at you for your thoughts. I'm not sure if you know the details, but the dad didn't fight the conclusions found by the lower court about who is the primary caretaker in this case, and that the child will have a much better life in the best interest of the child. So the judge applied two things. It was a real advantage, and it was also in the best interest of the child in this case. Thank you.
I don't disagree at all with the removal, and I want to be clear about that. The issue isn't that I'm bringing up is not the removal. The issue is the loss of custody. Because if you consider, if this man, as he was advised to do, attempted to move to Germany, and he tries to go there to get a job, and he asks for admission to the country, and he says, my daughter's living here now. What's the better thing for him to say? My daughter's living here now, and I have custody of her, or my daughter's living here now, and I don't have custody of her. I didn't read anything that suggests he should have not retained custody. I didn't read anything that said he was not involved in the children's lives. I do read a lot in there of what we used to see in probate, where people were trying to find the most minor differences to claim that one person's the winner. If you're a capable and fit parent, if you're capable of taking care of your children, if you do take care of your children, you should not lose custody. And I think if you talk to some of our newer probate judges, you'll understand that doing that lowers the conflict. What the SJC is promoting will only increase conflict. And this decision, I do not agree with any aspects about the custody decision. As far as removal goes, I do not have any issue with it. Thank you.
I don't want people to be left with the impression that dad lost custody and never saw his kid again. That's not what happened here. The father got 6 weeks visitation during the child's vacation, school vacations, and he could see her at other times as well. So the father could maintain as much, not as much contact as he wanted because they're separated by countries, but the father was given time to see his child and foster a relationship with his daughter.
Okay.
And again, the issue, I wasn't trying to suggest he wasn't going to see the child. I was pointing out that he did lose physical custody, and that means when his child is with him, the child is not in his custody. It's a difference that actually makes a matter. You didn't lose custody of your child, but when you do lose custody, and I didn't either, but when you do lose custody, it makes a difference. And I don't understand why the SJC wants to push taking custody away from.
Okay, thank you, Patrick.
Lieutenant Governor.
Okay, thank you. We have another, Councilor Hurley. Yes.
Just to be clear, Patrick, you said you were in opposition to this nominee, but in essence, you did not. You're speaking because you did not agree with the decision of the entire Supreme Judicial Court on a matter that was authored by Justice Cipher. Is that correct?
That's absolutely correct.
So you really have no negative attitude towards this nominee?
Well, to be clear, I've met with her, I've talked with her. I think she's a wonderful person, but I very much object to this decision.
Okay, thank you. Thank you, Councilor Hurley. Thank you, Patrick. Our next witness is Lauren Rabb. Lauren is participating virtually. Lauren, you may begin. We cannot hear you. If you need to unmute your line. Lauren, we cannot hear you. Lauren, we still cannot hear you. Wait, Lauren, there you go. Okay, you may present. Thank you.
Thank the Governor's Council for allowing me to speak today. I am actually not here for or against Justice Budd. I am here to relate my observations having gone through the court system as a pro se litigant. The Chief Justice of the Massachusetts Supreme Judicial Court is responsible for the oversight, promulgation, and accuracy of court-generated forms. I am a pro se litigant currently fighting fraudulent foreclosure in Central Housing Court. I'm able to find an attorney to take my case for less than a $50,000 retainer and not being able to get adequate representation provided for the court. I am left to defend my family home myself. In early July of 2019, I was instructed by the clerk's office to fill out an answer form found directly on the Housing Court website in order to answer the complaint filed against me. In your answer to complaint, the defendant needs to state they're reserving their right to a jury trial. There is no verbiage anywhere on the indicating anything about requesting a jury trial, and it was missing important post-purported foreclosure items that needed to be done to proceed properly. As a result of that incomplete court-provided form, I had to file a motion to undo what that answer form did not include. Most pro se litigants are probably not aware that this is even happening to them, let alone know how to see the issue after it's happened. I was lucky to have happened upon the Massachusetts Alliance Against Predatory Lending website, which has proper answer forms available. That erroneous form provided by the court almost came to the detriment of my constitutional right to a jury trial. In my motion to amend my answer, I made the court aware of the erroneous form, yet that form is still being provided over a year later. As someone who is navigating new territory while defending my home against a fraudulent foreclosure, having forms provided that were incomplete and didn't include basic information, it went from feeling like I was not only up against the plaintiff attorney, but I was up against the court as well. As an American, I expected the court would be looking out for my constitutional rights and to keep watch to make sure the judicial process is unbiased and fair, and that has been far from my experience so far. If even one person loses out on a constitutional right as a result of a court-provided form is one too many. I hope that Justice Budd steps into this role as Chief Justice, that she will look into issues like these that pro se litigants are up against across the state daily and work to preserve the rights of the litigants in the courtrooms of Massachusetts. Furthermore, I've learned that predatory lending and illegal foreclosures in Massachusetts is a large issue that needs proper oversight. I sometimes sit and say to myself, I can't believe these things are happening to people in America. Not only is it happening in America, it's happening right here in Massachusetts, and it's happening to me personally. I truly hope Justice Budd will be willing to make herself available for oversight in these crucial areas. In hearing the testimony before me, I am hopeful that she might be able to accomplish this. Thank you so much for the opportunity to speak today.
Okay, thank you, Ms. Rabb. Are there any questions from the councilors? Councilor Devaney?
Can you tell me, do you feel that you were prejudiced in court? Were you allowed to have someone assist you, to sit with you?
I have no help except for the Massachusetts Alliance Against Predatory Lending, which is a nonprofit, has been the ones that have stepped in to help me prepare my cases and network with other pro se litigants that are going through the same issues that I am. But I feel like when I step into the courtroom, I am not treated as an equal. I feel like I am an outsider. I feel like the plaintiff attorneys and the judges are working together and that I'm there fighting against the both of them. And I think that that's unfortunate.
Okay.
All right. I have heard, the reports that, litigants representing themselves have been bullied and even out in the hallway. And they have all kinds of assistance with them, but the self-represented litigant is left alone sitting there. So have you found that to be true?
Absolutely. I feel there's been several times where I felt like I needed to make a decision that wasn't quite right, and I felt a little bit ganged up on.
Right.
Okay.
Well, it looks like what I've looked into, and I thank you for having the courage to come and to say this and to present this to Justice Budd, to know that this is happening. You're not alone. I mean, I've researched, this is about 70,000 people out there in your position that have been treated badly. And these are women, these are people of color, and I understand. And I'm glad you brought that up for the public to hear. Thank you so much.
Thank you so much for the opportunity.
Stay, please. Counselor Jubenville has a question.
Thank you, ma'am, for your presentation. Where do you live?
I live in Holden, Massachusetts.
And what court did you go to?
I'm currently in Central Housing Court.
Okay, but have you gone to state courts with this issue?
No, I am currently awaiting for summary judgment. It has been put off now. This started in the summer of 2019, and I have not yet to even go for summary judgment.
And this is in the federal housing court?
No, this Massachusetts Housing Court.
Where's the location of the court?
It's in
Worcester.
Okay. And is it the same judge that hears your case all the time?
Yes, it is.
Okay. And what's the name of the judge?
Judge Horan.
What is it?
Horan.
Okay. And are you due to go back?
She actually just pushed off the case until January. She ruled to push it out on a motion from the plaintiff that I didn't even get a chance to be heard on. She ruled on it the day before it was supposed to be heard. So it'll be pushed out till January.
Are you still in your home?
I am still in my home.
Okay. Thank you very much. I appreciate it.
Thank you.
Okay, thank you very much, Ms. Rabb, for presenting today, not only for your own individual matter, but as you speak for others about access to justice across our Commonwealth. Obviously, a mission we all embrace.
Thank you so much for your time.
We appreciate yours. Okay, we are going on to our next witness. This is Dawn Duncan, participating virtually.
Good morning. Can you hear me?
Yes, we can.
Yes. Good morning, and thank you to the Governor's Council for this opportunity to participate in this important hearing. I also am here not to testify in support or opposition of Justice Budd's confirmation, but to present testimony that relates to important issues. My name is Dawn Duncan. I am a Native American homeowner in Lynn, Massachusetts, and a graduate of the Boston University School of Social Work and the Harvard School of Public Health. I'm here to share with the Governor's Council something that I believe the counselors need to hear to inform their deliberations. The particular question I raise is, what is the court's role in addressing structural racism as it relates to illegal and predatory mortgage lending that often results in an extremely long and protracted period of time between when the original illegalities occur and when they're even considered by the court? You're overseeing a court system in which, by the time it's being seen, in my own situation, for example, 14 to 15 years of questionable actions have been going on. I believe this issue is timely given the historic continuing rate of foreclosures coming into the COVID-19 pandemic moratorium, as well as the social awareness and awakening in our society that has come from the continuing violence against people of color. Lynn, Massachusetts, where I reside, is a geographic area that many sources document was the target of a lot of predatory lending. As an example, the color of money in Greater Boston, patterns of mortgage lending and residential segregation at the beginning of the new century, prepared for the Metro Boston Equity Initiative of the Harvard Civil Rights Project in January 2004 by Jim Campen, documents that Lynn had the fourth highest rate of subprime loans made of the 10 highest density cities in Massachusetts other than Boston. That was 15.3%. In my particular situation, at least 4 travesties occurred on day 1 in May of 2007. 1 being sold an overpriced loan, 2 being asked to pay a broker with no explanation of disclosures, 3 being rushed through signing of documents, and 4 not being informed about another party to the loan, namely Mortgage Electronic Registration Systems, MERS. Additional travesties continued for many years, including questionable loan assignments and obtaining a permanent loan modification in 2011, paying the monthly payment every month, and due to incompetence, disregard, or maybe something more sinister by the lender, having to file bankruptcy to stop a foreclosure auction on my home in 2012. Travesties in my non-judicial foreclosure continued, with hundreds to thousands of pages in loan modification applications and additional questionable assignments of my mortgage. Someone even forged my signature to a fake promissory note. Only in 2019, after 14 years of fighting a purported foreclosure, did I finally get in front of a judge at the land court. We often think of redlining as the act of systematically denying credit to people based on their race. However, in Massachusetts law, it also includes giving a mortgage that the lender knows is so overpriced that it's doomed to fail by ending in foreclosure. It's well known that unscrupulous lenders deliberately target people of color and women heads of household for these predatory reverse redlining mortgage loans. The Massachusetts Supreme Judicial Court on June 3rd, 2020, publicly took the responsibility to do more to, quote, root out any conscious and unconscious bias in our courtrooms. Our court's now finally going to address the clear structural racism in the existence of these predatory loans, non-mortgagees claiming to be mortgagees, non-lenders claiming to be lenders, and others. We hope so, and I thank you so very much for your time today.
Okay, thank you. Councilor Duff has a question for you. Ms. Duncan.
I do, and you don't have to have your mask on if you're online. But what I wanted to ask you is, have you brought this to John O'Brien at the Registry of Deeds? Because the Essex County Registry of Deeds will not accept any of the documents you have been talking about, and you could have ended this or put it on hold very, very quickly if you had spoken to him. I'm just curious if you knew or if you know that that is probably your quickest recourse.
Yes, I actually have been in touch with Mr. O'Brien, and I also work with the Mass Alliance Against Predatory Lending.
No, I understand. I'm very familiar with the Mass Alliance of Predatory Lending. I'm very familiar with this issue because I'm a real estate agent. But robo-signatures, forged signatures are not accepted in Essex County, period, stop. There is nothing else to it. And if you get that in writing from the Register of Deeds, the court will not evict you. It will not happen. I clearly understand what you're saying. I think it is a huge, tremendous problem. I think we are about to be overwhelmed in the next 2 years with foreclosures to a level that we haven't seen for a very, very long time. It's going to be incredibly scary, people losing their homes. And we are doing our very best, but there is a lot of education that needs to go on in our land courts. They are underfunded and they are understaffed, and we are working. I just want to give you some assurance, although it probably doesn't help you to feel much better, but we are working very hard. And I know Justice Budd will be asked today about funding for the courts, and particularly for the land court. Many of these issues that you're talking about are far more complex than our land court is used to dealing with, to be fair and frank. There is a lot of education that needs to be done for the judges, for the constables, and for the courts. So I know that probably doesn't give you a lot of solace, but please do bear with us because we are very keenly aware of this issue and we are working on it now. But I do urge you to follow up with Registrar O'Brien because he's actually won a Smithsonian Award for his work on predatory lending. The work he has done to keep people in their homes is really, really tremendous. And he is your first line of defense.
Thank you so very much. And that actually does more better than you even know. I
Okay,
appreciate
thank you.
it.
Thank you, Councilor Duff. Councilor Kennedy.
I've been mostly a practicing criminal defense lawyer for 37 years now. And read some of these issues that have come up, mostly in the newspaper. Really was not familiar with what was really going on here. As you're probably aware, I spent quite a bit of time over the last couple of days speaking with Ms. Ross, Attorney Ross, about these matters. And she educated me quite a bit. I was on the phone with her for probably 3 hours yesterday, 2.5 hours, going over these issues. I'm very, very sensitive to them, and I've notified the nominee. I'm going to ask her a couple of questions about them. I forwarded the questions that Attorney Ross had sent to me. I'm probably not going to ask them in the form that she asked. I think they're completely appropriate for the setting. But we are very, very sensitive to the issue. I think some of the issues that you're raising, very frankly, are not issues that we should be necessarily looking at. They're really legislative issues. And I hope that you're focusing your efforts, and you're focusing in the organization that's helping you is focusing their issues towards the legislature, because I think things do need to be fixed. I agree 100%. It was a great education for me over the last 2 days. I learned a lot, and I agree that there were some very, very serious issues that have to be addressed. But I think most of them have to be addressed through the legislature.
Okay, thank you.
Thank you.
Thank you, Councilor Kennedy. Thank you, Ms. Duncan. We appreciate your presentation today.
Lieutenant Governor?
We have, yes, Councilor Hurley has a question for you.
Yes. Has it been your experience in the housing court, or you're in the housing court, correct?
No, I'm in the land court.
Land court. In the land court, has it been your experience that you are not being treated fairly or appropriately as a pro se litigant?
No, I actually haven't had that experience. I have actually felt like I've been treated very fairly in the court.
Okay, because I think one of the things that's underlying all of this that is something that needs the attention of the SJC is the issue of pro se litigants and how they're treated in our courts. And as a district court judge for 20 years, after reading some of the things that have gone on, and I only dealt with it from the point of view of evictions long after the mortgage foreclosure had taken place. But I was shocked and appalled at some of the treatment that was received by the pro se litigants. So I think that's an issue that has to be looked at as well. And maybe appropriately, there should be a committee formed that looks at that in conjunction with this whole issue. Having been somebody who had a mortgage that was then assigned. You're a number. Nobody cares. Nobody is the least concerned, and the attitude is tough. And that's something that I think is totally inappropriate in any kind of a business setting. People who have mortgages, they're the customers. But there's also people who got sold a bill of goods that they could afford a mortgage, or that it would be looked at 3 years down the road, and don't worry about the interest rate, it'll all be taken care of. And that's nothing but out and out fraud. So none of this has to do with Justice Budd in terms of her competence and qualifications. But I think this is a good place to bring these issues up. And I appreciate your efforts, and I hope things work out for you. Thank you.
Thank you so very much.
Okay, thank you. Thank you, Counselor. Thank you, Ms. Duncan. We have an additional witness, and anyone else who is here that would present in opposition to the nominee. And I understand Mr. Al Salitro is present virtually. And before giving your testimony, I need to swear you in, Mr. Salitro. If you are able, can you please stand and raise your right hand? Okay. Do you swear to tell the truth, the whole truth? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you.
You're very welcome.
Mr. Salitro, you may present.
Okay, I want to thank everybody for this prestigious opportunity to speak on behalf of myself and others who unfortunately have been taken advantage of by predatory lenders. My case is probably not unique in simulation, but my mother had stage 4 cancer, and she was offered a mortgage, a 30 to 35-year fixed mortgage. Now, in common sense, I'm just going by the intentions of the bank, the predatory lenders. In contemplation, basically in common sense, who would commit to a 30-year mortgage based on somebody that had stage 4 cancer, number one? They're obviously not going to be able to obligate the completion of that mortgage in 30 years, given that factor. And me, as a legal heir, had taken over the mortgage and was paying the mortgage consecutively. And at the time of her passing, what happened, just to give you a little history, is the lending company did not want to revamp the loan. They said they absolutely couldn't. It was Fannie Mae backed, which, come to find out, yes, they can revamp the loans. But in my circumstance, they did not want to. They just wanted the property. And I believe that this was their intention to begin with, just given the factors. And so I was forced to be homeless, which I am now, and because of a direct factor in this. Now, when I was served to go to the housing court, they did not serve me properly. There was no constable. There was no... Basically, I found a summons on the ground, and yeah, I found it on the ground, and it was raining and so forth, so on. That's how I even knew I had a court appearance, per se. And when I'd gotten to the housing court, Judge Horan, well, I realized it was probably too late for appeals process at that point to file an appeals injunction or anything. So, but they would not let me even say how I had gotten to that event, how it had ended up in housing court from that standpoint. And I was treated very unfairly. I was told by the clerk of courts that I should take what they offer as cash for keys, I believe, which was $2,500 for my mother's residence at the time, her estate, that I basically had no choice but to accept that offer. And I believe a lot of litigants have been up against the same type of activity. And being blind and not being able to read documents, I really had no choice. I did have to take the advice of who I thought was professional in their diligence, the clerk of courts. But she advised me to take the agreement, not knowing what it entailed, basically. And so I was forced into it. I was forced to give up my mother's residence and forced into homelessness and forced into not paying a mortgage, which I had been doing. So I really don't see anything unlawful with that. I don't understand why a bank would basically not accept money. All I can fathom is that their intentions were out to flip the properties, if that's the correct term, that their true intentions were to take these properties from people that they knew could not carry out their mortgages and not allow them an opportunity to, at that sense. So I guess basically what we're trying to do here today is open a moratorium on this whole cause and effect that the housing has seemed to cause people, and it seems to be forcing more and more people into homelessness, which is basically out of control at this point. And with the epidemic, I understand that this also adds conflict, but what we're looking for basically in the housing court is a fair shake, and we're not getting that. Pro se litigants are absolutely prejudiced against, just based on that factor alone, I believe, in my own personal experience. And I don't believe there's enough attention given to these litigants to say, okay, is it a fraudulent circumstance? Is it not fraudulent? How can we better address this and make this better enforced? And I don't believe we're getting that chance to do this. We're asking for some type of reform and some type of action that may be taking that says we may be able to present ourselves without being prejudiced against.
Okay. Mr. Salitro, thank you. Members of the council, Councilor Devaney.
Thank you, Mr. Salitro, for your testimony. I think that this is something that, that the public should know. And I've looked into your case, and it's so egregious, I can't even say. And so I do want to, just to give a little more history here. First of all, you were a self-represented litigant. And and so with no notice, a housing court threatened you. Now, correct me if I'm wrong. With no notice, a housing court judge threatened you in open court either to work something out with the bank that morning or else go to jury trial that afternoon. Now, you were told that the housing court starts jury trials in the morning only, which is not true. They only start in the morning only. So that threat was false, okay? Now, the other thing is to note, you have been blind from birth.
Correct.
So obviously you cannot read. So in the court-ordered mediation, it was the bank's lawyer who read aloud to you the agreement for judgment that you then signed. The agreement stated falsely that Mr. Salitro had read it. The court mediator had no problem with the blind defendant signing away his rights to his home like that. Neither did the judge. So the judge signed off on it. And so you had not defaulted on your joint mortgage with your mother.
No.
The mortgage service have refused to accept payments of the total monthly amount after your mother died.
Correct.
There then it was foreclosed. So looking into this, because I mean, this is a big issue now with foreclosures, and this has happened in so many other cases. And so sadly, which you really didn't talk about, you only got a few $1,000s cash for keys for the family home in which you grew up. Yet the Judicial Conduct Commission had so little problem with this judge's conduct that it rejected your complaint without even docketing it. So to me, the conduct of the Judicial Conduct Commission should be addressed.
Yeah.
And this is something I'm heartbroken for you. And I think from what you said, we'll start here and see if we can help in any way to get you the services that you deserve. So obviously, to me, the commission is not being fair, and you have been treated so badly. And I understand you're a single father too?
Yes, correct.
Yeah. Well,
my daughter was also displaced because of it. Yes.
Right. Well, and you're homeless. So where do you live now?
Well, I live in the town of Spencer. I was recently displaced by fire, and I'm in a rooming house. So I'm just.
Yeah, right. Well, this is the place, to come, because it gives all the justices that are here, an awakening of what's happening. And you are a symbol of those people out there. But to say that you read something which it wasn't given to you in Braille or any way that
It
you
was
could.
basically impossible, yes.
Right, right. Well, we can't go into it all here, but, I know Justice Budd is listening, and it's not going to end here. And I'm so sorry for what you've had experienced. No one should be treated like that. And, we do have mentoring for judges, and I think these judges need some mentoring very badly. Okay, so thank you very much. Okay, thank you for your testimony, and I am personally very sorry for your experience.
Thank you, Councilor Devaney. And Mr. Salitro, thank you. Mr. Salitro, thank you for presenting today. We heard you. And as Councilor Devaney said, others have heard you, and there will be some follow-up that Councilor Devaney will pursue. Thank you, Mr. Salitro.
Well, thank you very much.
Okay. I would like to ask if there is anyone else that is present that would like to testify in opposition to this nominee. Okay, this concludes this portion of the hearing today relative to witness presentation. So I can gavel that portion closed. And now we're going to turn to the nominees' presentation. And after Justice Budd presents, we will take a brief recess and then come back to this room to begin with Councilor Devaney's questioning of Justice Budd. With that, we turn this over to you, Justice Budd.
Thank you. Councilors, Lieutenant Governor Polito, I'm extremely humbled and honored to come before this body again, this time to establish to your satisfaction my worthiness to be confirmed as Chief Justice of the Supreme Judicial Court. I'd like to thank Bob Ross, the Governor's legal counsel, and Lauren Green Petrino, his deputy legal counsel, for their seriousness with which they have taken the vetting process to fill judicial vacancies, including those on the SJC. I'd also like to thank again Governor Baker and the Lieutenant Governor for nominating me for this position. I am beyond honored by the trust and confidence that they have placed in me to continue public service in this leadership role. I want to thank my witnesses for taking the time to be here and for their very kind words. And I especially want to acknowledge the presence of my fellow justices on the SJC bench. They're all here. Justices Lenk, Gaziano, Lowy, Seifer, and Kafker. I'm truly grateful to have them as colleagues. We spend quite a bit of time together, now virtually, and although we come from different backgrounds and have different points of view, we work very well together. We even manage to have some light moments, although our work is very serious. The fact that as a group we are so collegial is due in great measure to Chief Justice Ralph Gants. His heartbreaking and completely unexpected passing is the reason that I sit here before you today. He led the SJC and the judiciary with compassion and humility. He was a mentor and a friend, and he is missed every day. I also want to acknowledge that the way was paved for me to be here today by several former justices of the SJC. Rick Ireland and Margaret Marshall, both who served as Chief Justices and who both still vie for the title of being the first African-American Chief Justice. And Ruth Abrams and Jerry Hines, who both served as Associate Justices, being the first woman and the first Black woman, respectively, on the court. Because each of them came before me representing a first in their respective class, I believed that I could do it too. I proudly stand on their shoulders here today. I'm sure that it will not come as a surprise to anyone here that being a Black woman in this country has framed my personal and professional experiences, including my roles as a mother and a wife, as a lawyer and a judge. Like so many people of color, I have had the experience of being dismissed or overlooked. Because of that, I did my best as a trial judge to make sure that defendants and pro se parties who came before me and who may have felt powerless knew that they were seen and heard. In the same vein, as an associate justice on the SJC, I was able to bring a perspective to the table that otherwise may not have been considered or appreciated. I'm sure you understand that the lens through which we each look at issues, and many times even the issues themselves that we face, can be very different based on the characteristics that distinguish us, including race. If confirmed as Chief Justice of the SJC, my lens will continue to inform my work. I've had the good fortune of having parents and extended family who have provided a stable and loving environment. It allowed myself and my sisters to thrive. I've had the opportunity to get a good education, for which I'm grateful, and my work experience, which has been both in the private and public sectors, including sitting as a trial and appellate court judge on civil and criminal matters, has served me well. If confirmed as the Chief Justice of the SJC, I will use my education, skills, and experience to provide calm, steady, and unbiased leadership to work through the issues, both chronic and acute, that are brought to the steps of the courthouse. These are unprecedented times, and state governments are more important than ever. It is imperative that the people of this Commonwealth have faith in its institutions and that our government functions as it's meant to, including the judiciary. I don't claim to know all the answers to the issues that the court system currently faces, and I can't predict the future. But I have faith in my judgment and my ability to make reasoned decisions based on the best information available. And I know that I can rely on the support of so many dedicated public servants who are committed to making sure that the court system continues to provide justice in the midst of the current challenges we face and whatever is to come. When I appeared before you 4 years ago seeking confirmation as an Associate Justice of the SJC, I promised that I would do my best to serve with distinction and strive every day to honor my oath of office. That is to uphold the laws and the Constitution of the Commonwealth and the Constitution of the United States. I believe that I have done so. I promise you today that if confirmed as Chief Justice of the SJC, I will continue to do my best to uphold the rule of law, to ensure that everyone has a voice, and to see that justice is done. I would be remiss if I did not thank my husband, Bill Thompson, my father, Wayne Budd, my son, Will, my niece, Olivia, and my godfather, Tom Riley, for being here with me today and for their love and support every day. My younger son, Evan, could not be here in person, but I know he's rooting for me. Because of the pandemic, we've got a smaller group here in person than we otherwise might have had. Nevertheless, I have to thank my extended family, friends, coworkers, and so many others who have supported and encouraged me over the years. I know that without their backing, I would not be here. Counselors, thank you so much for your time, and I look forward to answering your questions.
Okay. Thank you, Justice Budd. We will take a brief recess. We will take 10 minutes so we can be back here to begin the questions for Justice Budd. Thank you very much for your opening statement. Brief recess.
on you, but they haven't gone live yet, but we're going to do it.
So I tried the phones. So definitely the pink, the sleek one is cool, but it fails with what I need to accomplish is to have something here that I can lean on. It's too sleek.
I thought it was cool looking,
but it totally.
I thought maybe you needed two, the one upstairs, one downstairs.
I do need two, but that's not the one. It says more miserable than just holding the phone. So what I'm going to do is I will well, you're going to
Want me to order another one?
exchange
it.
Exchange.
Send that black one back.
The black sleek one back, and the thing for it, sticker or whatever. I'll mail it. Just get me the gift for it, and then just buy me another one of the other one in a different color.
Okay, what color you want?
You know, black maybe. Yeah. So there's a pink and a black.
Yeah, I figured the picture was supposed to be red.
Well, it's more like.
Well, I figured that way.
I'm going to actually probably buy another one myself to put in the Christmas. It's just put in the Christmas because I need one in the car. I need one upstairs. I need downstairs. I'm on the porch. You know, I would have one.
That'll work.
Yeah, yeah. So if I have a couple of them here and there, and I don't have to think about it, I got one in my desk. I don't want to move things up.
That's what I thought.
Yeah, because the phone itself is enough to have to move. And, then again, maybe it's better. It's true. I have leave one in the car, leave one upstairs, leave one downstairs. So if you replace, you get me a new one.
I'll get you two new ones.
Okay, get me two new ones and we can put one in the Christmas. Yeah, whatever.
You can use them. They're not expensive.
You know how you have your trees. I have my Christmas tree. And it's one thing we got it all figured out, me and Austin. We had it working really nice. That we give him money, we take him clothes shopping. He picks up what he wants, whatever. But we're trying to quote make Christmas for Howler. So really, it's about I think cheap small things. I don't think it's buying any more expensive things and just giving again packaging money in different boxes, you know, stuff like that, gift cards or whatever. But yeah, I think, you know, because they'd rather buy their own shit. I don't really go crazy buying stuff, but we got them each a pair of boots and a couple of little things here and there. And then, yeah, just stuff to open. So in that mode of just buying stuff for them to open, you know, stuff like this, just have. And you say, oh, Sharon, I have another gift for you. Oh, Ellie, I got another gift. We don't even need to you don't get what I'm trying to say. But it's because it's a confusing thing for me. How to, like, we had it figured out. We finally had it figured out. And
hopefully there'll be children.
And it'll be all about kids. But this year it is. And seeing the kids, and having a lot of decorations. You know, even also because it's just about opening things. That really is the spirit of Christmas.
Well,
for children.
Right.
They just want to keep opening. They want to keep opening. It's not like they're going to stop and play with it.
No. Well, fucking drove me nuts. Christmas drove me crazy. Christmas would always last all day.
But it's people, and so I actually tried to open it. But there's something going on here. Yeah, SJ's calling.
Hi, Jess. Hold on. Can you hear me? Okay, what's up? Hi.
shoot. It's not supposed to be. They had us, oh my God.
section of our hearing today of Justice Budd. Thank you all for returning. Break was very helpful. We would like to continue with questioning by our council members, and we will begin at this moment with Councilor Ferreira, and then when Councilor Devaney returns, we will go to her next. Councilor Ferreira.
Thank you, Governor. Thank you again, Justice, for your service to the Commonwealth and for what you've done throughout the years. You and I met several years ago before you got on the court. We spent some time together outside of the council, and I got to know you and really appreciated the opportunity. I think you're doing a fantastic job. You've been vetted and revetted again. And I'm not one to ask questions for the sake of asking questions over and over and over again. You and I did discuss one thing. As you know, I spent 30 years as a police officer, like your grandfather, 9 as chief of police. So I have friends. I was a special prosecutor. I've been a lawyer for 28 years as well. I do some defense work, but I've been out of civil practice for 28 years while I was a cop. I was there part-time. So I got friends from all walks of life. And I have to tell you, I'm a huge fan of diversity. I've personally held classes with members of the governor's office on how to recruit diverse candidates. And I'm pleased to tell you that a couple of people that came to the class are now judges in a district court, juvenile court. So I am a huge fan of diversity in our courts. I do have some concerns that we talked about, and maybe you could just shed some light. And that from the law enforcement people, of course, you know. And I was on the phone with the chief on the way up here, and he said, "Can you please ask her?" You know, so what's happening, and it's it evolves around racial profiling. I can tell you, when I was a detective lieutenant in Somerset, one of my sergeants stopped a car on a Sunday morning, and racial profiling came into effect right away because at the end of the traffic stop for impeded operation, they uncovered 2 sets of hands that had been cut off. These guys just committed a double murder in Providence, Rhode Island. It went through the court system, and it found out, the court decided at the end of the day it was a lawful stop. And then fast forward, some police officers, and maybe you can shed some light on it, because I think a lot of police officers, they read, whether they read the Globe or they read the Boston Herald or whatever they read, and they go, geez, we can't, our hands are tied, no pun intended, our hands are tied, we really can't do our job anymore because of Commonwealth versus Long. And I think some of them don't understand how that's actually carried out in life. But I can tell you that, I talked to guys today, and they're like, the word on the street is R2I. You respond to an incident. You don't stop anyone. You don't, no contact, no issue. So, of course, we all want police officers to do their jobs. And as a police chief, I enforced rules and regulations, policies, and procedures. And I had one case where someone lied to us during an investigation. And as you know, under Brady and Giglio, that officer can never testify again, because at every time that officer would testify, we had an obligation to tell the defense lawyer he's a proven liar. So I had to have that officer resign or be fired. And cops are concerned now that if one of the questions that we talked about is that if they are deemed to have been biased in a stop, even though there's an objective motor vehicle infraction, there's an inspection sticker. It goes through the Commonwealth versus Long analysis now. Cops are concerned that if they are found to have been biased, the judge somehow reads into the officer's mind that it was racial profiling and not just for the sticker based on the occupation of the cop or, whether his job was to stop cars or not. And it goes on, but whether or not their credibility would be called into question every time they testified. So chiefs are concerned, geez, can I have that guy respond to a murder? Can I have him respond to a B&E? Or is he going to be, first guy in the scene? And the first question is going to be, weren't you the guy that was proven to be biased against, diverse people? So those are concerns from law enforcement, and you and I had conversations. And, I'm not asking you any direct question about it, but maybe some thoughts, and maybe if you could shed a little light on how it's going to play out, and, if you care to, that might be beneficial to everyone involved in the process.
Sure.
Thank you.
Okay, so first of all, it's important that police officers can do their jobs. We rely on them for public safety, and they're essential. In terms of the Long decision, I just want to emphasize that that didn't change the law in any way. It's okay to stop people for a traffic infraction. It's not okay to stop someone because of their race. So with those things in mind, Long gave defendants an opportunity to show that they have been stopped because of their race, an opportunity to prove that. Back in 2008, we had Commonwealth versus Laura. That's when the court first said you can't stop people because they're Black or a different race. But we said that in order to prove that, defendants have to show statistics. That was back in 2008. It hadn't ever been done between then and now. So we realized that that wasn't enough. It didn't allow defendants to actually make a preliminary showing. What Long does is allow defendants to look or to show the judge the totality of the circumstances, everything that happened, and then the judge decides whether or not they think that there was racial profiling involved. So racial profiling is not okay, right?
Right.
And this is just about how a defendant can prove it.
Understood. Back to the testimony by Patrick McCabe earlier, and we talked about the Miller case. Do you still stand by what you told us a few years ago, that shared physical custody should be the norm, all other things being equal for parents?
You know, these issues are complex. Every fact pattern is different. I believe that we have to let the judge and the probate and family court make the findings, figure out what has happened. And it's our job, frankly, to figure out whether or not the judge has abused his or her discretion. So there is no question in my mind. Two parents are important. And if there can be joint custody or, you know, however it works best for the children, that's what should happen. That's what I believe.
Right. Judge, I want to tell you straight, you have my vote next week, and I know my other councils have other questions for you, so I'm going to be finished, and again, thank you for your service to the Commonwealth.
Thank you so much.
Thank you.
Thank you, Councilor Ferreira. I'd now like to invite Councilor Devaney to question the nominee.
We meet again.
Good morning. Good afternoon.
I can't tell you, Judge Bud, how honored I am that I shared your journey and your whole journey in this judicial experience from the time 11 years ago in another administration. And as the district counselor is designated for the past 60 years to preside over your hearing, I was so proud to be presiding over your Superior Court and through the years. And I just wanted to follow up on some of the things that was said about joint parenting. I want to tell you that I belong to Women in Leadership for Shared Parenting. And I think for too long, fathers have been, in the past, have been just left out, and it's just a given that the mother is going to have custody. And we know how fathers are so involved today. And I just love it when I see fathers alone pushing a baby carriage. And I have to date myself. I remember my husband was the only one that I knew that pushed a baby carriage by himself. So we've come a long way. But I don't know whether we've come enough of the way for parents, okay? Now, what criteria would you use to allow a parent to move with children, to move away with children?
You know, this is something that judges in the probate and family court deal with all the time. and they have to look at each case and the facts and the specific circumstances of each case. And I know it's got to be a very difficult job. It's got to be a very, difficult decision. And we hope that the judge makes a decision that is best for the child. And, we have the appellate process to allow for someone who is not happy with the way things have gone, bring that to the appeals court or to the SJC. But it's hard to say, just what are the criteria. Every single case is different. Every family is different. The kids are different. And all of that has to be taken into consideration.
Well, I guess what will always stay in my mind was a judge that was voted 19 years ago by the Governor's Council. And I will never forget this. I read in the Boston Globe about this judge after she was on the probate family court for, I don't know, probably a year. And there was a young mother who moved to Oregon from Massachusetts with her 3 young toddler children. And I looked and I couldn't believe that, she allowed that. But what really, really grieved me was that she gave, I hate the word visitation. I hope they threw it out. I think they did. They gave the father 1 hour on the internet from 6 to 7 to see his children. You can't hug a computer. So he's divorced from his children. Now, in that case, she had no family waiting there. She had no friends. She had no work. She had no one there. And looking into it, the father was devoted to the children, and he lived close by to where they lived. And he used to see them every day. And even on Christmas Eve, he would stay overnight to see them get up and open their presents. So, to have this man divorced from his children, what criteria was used? There wasn't any. And it was so bad that it was written up in the newspaper. Terrible. But you know something? I don't have a crystal ball, and I don't know how people are going to be on that bench. You have never disappointed me. I've always been so proud, and always proud to be your district counselor, and I'll always hold that. Now, do you believe that good fathers not giving the same consideration as mothers in parenting time? How do you think that's going now in the court?
I hope that, I know that things were different, years ago. I hope and I believe that judges consider the positive effects of both parents being able to spend time with their children. And I think that's something that judges
So 50-50 even in contested?
I don't know about, it depends on the specific circumstances.
I understand, but, as I said, I think we've come a long way, but I think we have a lot of good fathers out there, and there's so many fathers that are at home now while the wife is out working. It's a whole different, lifestyle that when I was bringing up my children, and I know my husband spent a lot of time with my children, but I just think in a divorce situation, the fathers have not been considered equal on that. So, okay, so let's go back to, I'm very concerned about what's happening in housing. I mean, when you hear Mr. Salitro, a blind man, I mean, how much discrimination could you have against a disabled man? And so they did everything dishonest and everything, and he lost everything. So I have been looking into a lot of this about the foreclosures, and a lot, because of the situation, a lot of the litigants are self-representing, and they're not given from what I'm hearing, some instances, they're not given the respect or, that the lawyer is getting, and all of that. So, okay, so knowing that, the judge will not allow continuances, I've seen that, to a litigant who does not have a lawyer representing him. And yet that person is supposed to represent himself as a lawyer, and it just isn't fair. So now in the land court, I've learned that they accept a plaintiff representative that's the mortgagee, but he doesn't have to give any evidence to prove it. How can that be allowed in court? Because we have these non-existent entities who this innocent person who does not have any legal assistance is, loses their home and everything else. So do you, and it was said, and I know it's women, it's people of color, it's people with disabilities. The most vulnerable are being taken advantage of. And, what can you do about that?
Well, I was moved by the testimony of the witnesses who were having issues with foreclosure, and there's no question that they're at a disadvantage because they are pro se. They don't have legal training. They don't have someone to represent them. And that's an issue that we definitely have to continue to look at. Chief Justice Gantz was very...
this was his thing?
Yes, that's right. So that's something that obviously I think is very important, and it's something that we will continue to work on to make sure that everyone has equal access to the courts.
Okay, now Massachusetts has been called a title theory state. Do you think it's important?
Yeah, I'm not sure that I know exactly what you mean by that.
Well, here I am, a layperson. In a mortgage of real property to secure a loan, the borrower has to show the legal title in the mortgagee's property to the lender. But we don't know the mortgagee lots of times, and it's fraudulent. And so do you see the Commonwealth being a title theory state? Do you think it's important, I should say? Do you think it's important?
I think titles are important for property. Are you talking about in the land court?
Yeah.
Yeah.
Yeah, I'm very disappointed to hear this coming back from people, and it's legitimate. They're not making it up. I've learned that the Uniform Commercial Code is a comprehensive code that's used in 50 other states. And it's a code that governs all commercial transactions in the United States. Now, 50 have adopted it. Do you think the Uniform Commercial Code is overly stringent, or do you like as it is?
Yeah, I never really practiced with the UCC, so I don't have much to offer in the way of whether it's overly stringent.
This is going to be, before you, this is a big issue with the pandemic, especially people out of work, losing their homes. And, as I said earlier, 70,000 mortgages in Massachusetts are incorporated in New York, and they do not have to go before our courts to identify who they are. I mean, do you think that should continue?
I think we have to have strong rules in place to make sure that the documents that are presented to the court are authentic. And I think it's important for the judges to make sure that happens. I'm not making this up, I have really looked into it. There are reports of some judges, and sometimes their clerk magistrates, have come to see their authority as an excuse
to bully litigants, especially self-representing litigants. And they expect the self-representing litigant to be a lawyer. And sometimes there's 7, 8 lawyers against this one person sitting on a bench. And that person isn't even allowed to bring any devices, a cell phone or anything, but the opposition has all of that. And the lawyer. So, I mean, I can't believe this is happening because I admit my ignorance in this, but I've really dug in and I'm looking for your leadership now to look into this because this is going to continue. More people are losing their homes in this pandemic. The other thing is, the Judicial Conduct Code, doesn't that require a judge to control the behavior in that court? Or am I mistaken? I thought that's what it was to do.
The Judicial Conduct Commission?
The code. Yeah.
Yes, so judges are supposed to act in a professional way.
Okay. Okay, do you see any vote of Massachusetts Supreme Judicial Court to address the conduct of such judges or clerk magistrates? I mean, this is access to justice, or is it charged to the Mass Board of Overseers? I mean, this is new territory that, it has never been, I don't think has really gone before the SJC as much as it is now. I mean, it's so sad to see so many people and, people with children living in cars and everything. I never thought we'd come to this in this country. But, with this, it's just not financial. It's not just homelessness. It affects people's health, their children failing in school, suicide. It's everything. And so we've got to address it really now. Can you do anything about the Judicial Conduct Commission rejection of complaints by represented litigants? Can you do anything about that? I don't know what the authority is, so I admit my ignorance.
Yep, so the Judicial Conduct Commission receives all complaints from litigants about something that the judge has done. And usually the Judicial Conduct Commission looks at each of those complaints and decides what to do with it. The SJC does not get involved in those cases unless it's something that is serious enough to come to the SJC.
No, and I know Justice Gantz, God rest his soul, this was something that he was in the middle of this to address. And, where is this going to be in priority now when you take your seat as the Chief Justice?
So, Chief Justice Gantz, I think it has already been said, he has large shoes to fill. He seemed like he did almost everything, and he had a lot of projects. They were all very important, and I'm not sure how he did it because, he got all of his cases written. They were brilliant. He had time to review all of our cases and give us comprehensive comments on them. And he also worked on access to justice, racial discrimination, systemic racism. He worked on the eviction issues. He worked on so many things. I ask that you give me a little time to figure out all of what's going on and figure out how to.
Of course. And I know, like I said, this is, uncharted waters, I know. I mean, we've never gone through a pandemic. We've never gone through, I have a son that's out of work. I mean, it's affecting everybody. And so I'm just thinking of Mr. Salatro, a blind man, who they said he read this, he couldn't read it, all of it. And to say that, that he had to sign that or it would go afternoon court, and they don't have afternoon courts, they're in the morning, all of the lies, and they took his house. He's homeless. Now, what can we do something now? It's after the fact. What can we do now about those judges about those, to hold them responsible, just as him, as a poster child for all of the people who have gone through such experience as he has. I mean, is it just that he just has to go on with his life the best he can, or is there any retribution for this?
Yeah. We've got an appellate process. I'm not sure where he is in that and if he did appeal and if what happened with that. All I can say is everybody tries to, that we have a system, it's not perfect, it's flawed. We're doing our best. And we do have ways to appeal these types of decisions. And it just has to go through that process.
But I have seen that the Conduct Commission does not go to bat for people like him. And that's where I'm saying he's done. He's through with court. He gave him a few dollars, gave him his keys, and he's gone. And, I can't forget him, and he's representing 70,000 more people. And I'm just saying, I don't expect you to answer today, but what can the Supreme Judicial Court do for these people to advocate for them after they have been wrongly treated, who have been lied to, who have been bullied? I mean, I read about this woman, she was all alone, sitting there on a bench, and she was bullied by the judge and bullied by lawyers out in the hallway, and she left there crying. That's not justice. So, I don't want to be redundant, but all I'm saying is, please bring that before, the Supreme Judicial Court. Let's see what we can do with these people who have been unfairly treated, And so I think that's really the priority now, to get people to know that justice works in Massachusetts. And for me, as a counselor for 21 years, in voting for how many hundreds and hundreds of people, I don't know everything that they're doing. And probably some of these judges or clerk magistrates that I voted for are bullying. I don't know. But I can't be all over the state in every courthouse. I do my best to go to parole board hearings and whatever I can do. But this is something that really touches my heart. And this man is a symbol, Mr. Slotra.
Yeah, I mean, as you're speaking, one thing does come to mind. A litigant who's not happy with the way he or she has been treated by the clerk magistrate or the judge can talk to the first justice in that courthouse. And that's the person who is supposed to be in charge of what goes on in the courthouse. And if they don't get satisfaction there, they can go to the trial court chief, Paula Carey.
That could be true, but someone in his position doesn't have someone to assist him to do that.
Yeah.
He went through a lot. He took care of his parents that had Alzheimer's. He's gone through a lot. And to be born blind he's had some good jobs. He's worked hard and he's just won. I'm so glad he came. It doesn't apply to you right now, but I'm just saying, do we just forget them and let's go on with the next one? I can't.
No.
So I'm just hoping that would be on the agenda to see what we can do for people like him. And also to seek justice against these judges and clerk magistrates who are lying, who are bullying, that you got to sign this, and said he signed it and he can't see. I mean, it's unbelievable to me that this is happening in Massachusetts. Maybe I'm naive, but I believe in justice, and it's disappointing to me. So I think that's it. I think, the other thing is with parenting, there are so many divorces now, and we have to think of the children. Children deserve two good parents. And if they're both good parents, then they should have access to those children. And, I don't think in a lot of ways it is even. So those are the things that are uppermost in my mind and in my heart. And, I lie awake nights thinking about people like him. It's not fair to be lied to. And those people keep getting away with it. They have mortgagees that are nameless. their corporations, their banks and everything in New York and everywhere else. And the judge does not require them to identify. I don't understand it. But anyway, I've gone on too long, and I'm just over the moon today. I'm so excited because I have a philosophy: you promote from within. If you work at Dunkin' Donuts and you know, and the boss has left and you're the assistant, you've done a good job, you should get it. Don't bring someone from outside. That's disrespectful. So I can't be so, and you are blessed to be with the best judges that we have in Massachusetts. And I am so honored and proud that I have voted for every one of them. Just one in 21 years, and she's gone. So let that go. But I'll tell you, I do want to mention Justice Link. I really feel she's the unsung hero. There wasn't anyone that I have met that has such a quiet demeanor, temperament, and she is so dedicated. She works late, she works hard, and I don't think people realize. But you know what? I'm going to keep trying to change that 70. And you know who's behind me wanting me to do it? Justice Jerry Hines. So I'm over the moon. That's all I can say. And how wonderful that you have family here to, you know, to participate in this wonderful. Imagine the highest position, judicial position in Massachusetts, and you deserved it. And you're in my district.
Thank you so much.
So
Council.
thank you for all the time that you have given me through this whole process and through the years. But 11 years. You come a long way and you work for each step that you've taken.
Thank you very
And I'm
much.
pleased.
Thank you,
Thank you so much.
Thank you, Councilor Devaney. We can now move to Councilor Jubinville.
Thank you. How are you?
Good.
So I told you that I would tell the story that I received from two people in Springfield about your grandfather, Captain Bud. They said you didn't want to get sent to Captain Bud because you would be treated pretty severe, but you would be treated in a fair way. And they said, but what he did do was he saved so many young people from quitting school or different things that because they were afraid to go to him, so that they would straighten out after that. And I'm sure he had his hands full with your father and his good friend, former Attorney General Tom Riley, running around the streets of Springfield.
I've heard stories.
Yeah. So that was an interesting story. I got a kick out of that. Let me ask you a couple of things here. I'm just going to read part of this letter that Judge Ireland signed and Judge Hines also along with. I think it was 40-something judges regarding the charging by the U.S. Attorney of a sitting judge in Massachusetts. And I'm not talking about what was alleged to her. My question is going to be on a more general sense. So the letter, and I'll read parts of this letter. The recent indictment of a sitting Massachusetts state court judge initiated by the U.S. Attorney unnecessarily and inappropriately impinges on state authority over its courts and threatens judicial independence. We, as retired members of the state judiciary, stand firmly in opposition to this ill-considered intrusion upon the long-standing and well-established right of our courts to operate free from federal interference. Massachusetts judicial system is parallel to and not subordinate to the federal system. The Massachusetts court system faces a crisis born of escalating efforts to disrupt and interfere with its proceedings by federal officials implementing immigration policies advanced by the current administration. It would be unthinkable for the state law enforcement authorities to enter a federal courthouse to arrest a defendant or witness irrespective of the status of the federal case. Yet, in the recent past, we've seen federal intrusion into the administration of justice and federal courts. It is a duty of state judges to resist outside efforts to influence and intimidate trial court judges and employees and to interfere with state court judicial proceedings. Escalation of undue pressure by federal officials is clear in light of the recent federal indictment of a sitting judge and a court officer arising from conduct in the course of their official duties. Whether the conduct of the judge was appropriate or not, federal indictment is a draconian response. And they talk about sending a chilling effect on all of our state judges. I do believe it was intended for that. I don't believe any federal judge, any state judge would be charged by a U.S. attorney without the okay of the United States Attorney General, and in this particular instance, the White House. So I believe the purpose was to have a chilling effect on our judges and to send a message that this wouldn't be tolerated. Again, not what she's accused of doing, whether she did it or not isn't the point, as mentioned in the letter. But just the overall action by the U.S. Attorney's Office, if you could comment on that.
Counselor Jubenville, I'm sure you can understand that it wouldn't be appropriate for me to comment on an open case or on, the specifics of the case that you raise, because it or issues like it could come before the SJC in our role as general superintendents. I can say that I think judicial independence is extremely important, and that's one of the reasons why I'm glad I live here in Massachusetts.
Well, has there been any guidelines established by the SJC with regard to this issue for our judges in our courts?
There have not. I mean, it's still an open case, and we do not.
I understand it's open, but I'm talking about the intrusion from a federal point of view to our state judges. There's been no guidelines as far as what our judges are supposed to do with regard to illegal immigrants in this case.
Well, judges have independence and discretion to do what they think is best in their courtrooms. And so we do not have guidelines right now. Maybe it's something we need to look at, but I think it also depends on what happens here.
Well, I think what happened here, and I'm not talking about what the disposition might be at the end. What happened here, in my view anyway, was an intentional action from the highest authorities in Washington to let our judges know that we're watching you and you might be the next one we haul down to the federal building and put charges on. Has there been any kind of discussion about the chilling effect through our court system on this?
Yeah, I mean, there have been individual conversations between judges.
Let me ask you about. What was I going to ask you about? Let me ask you about the legislature and how you will deal with them as far as getting them to give our court system more funds to operate. And as I indicated earlier, I think it's 1.5% of our state budget, which is really hard to kind of fathom that an equal branch of government gets 1.5%. And with that, we're still able to do so much. But can you imagine what you would be able to do with 5%? How do you unlock that purse over here in the legislature?
I don't know yet, but I'm going to do my best to find out. I know that Chief Justice Gantz and Chief Justice Ireland worked very hard and worked with the legislature, trying to educate and make sure that we've invited them to come and see what we do in the courthouse. I think I need to do some outreach. I know that Chief Justice Ireland has offered to give me some tips, which I will happily accept. And I absolutely agree with you. We've got to have appropriate funding in order to do what we need to do every day. The court system is very important to a lot of people, and even for those who don't use the courts every day, it's very important that they have faith that they could use them and that we're there.
Well, if Judge Ireland isn't going to take the job as the lobbyist, my suggestion would be for the court system to hire one. There's other lobbyists for state agencies that get hired, and sometimes they're ex-legislators or ex-senators or people that are good, that have good relations with the reps and senators. And I think it's important that the court system have one of those. I think years ago, the juvenile court used to have a sort of a lobbyist that would advocate for them, but I just think it's too important just to come over and say, please, fellas, what do you think? They're never going to give it to you like that. It's got to be somebody that knows reps and senators well and knows how to move over here. So I think hiring a lobbyist would be money well spent.
If we can find the money.
Yeah.
Yeah.
Well, it's money that's going to probably one of the only jobs where it's money that's going to end up getting you back 10 or 20 fold for that salary.
Yeah, I'll have to look into that seriously.
Because this is just not right to have this much money out of a state budget. I'll ask you the same question I asked Judge Gantz when he was here. That you're going to be the head of the equal branch of government in the Commonwealth. Yet you're the only person that has that status that has no check and balance on you. And, you know, the legislature, they have to go to the voters. The governor has to go to the voters. The chief judge doesn't have to do that. So I asked him, and I'll ask you the same thing. Do you think there should be like a time limit on like a 5-year term as the chief judge? And then if for some reason you either don't want it again or there's some reason you go back and sit in a regular court and a new chief judge takes over for the 5 years.
Well,
I don't expect you to say you want to do that.
You don't expect me to what?
Say you want to do that.
Oh, okay.
But just philosophically.
No, I understand. I absolutely understand the concern about having a check on power and that this is not an elected position.
Yeah.
I still feel like we are accountable to the people, frankly. And I mean, for my part, I hope that you feel comfortable with my track record, what I have done as a lawyer, as a trial judge, as an appellate court judge, and feel like you are comfortable with how I would perform as chief of the SJC. I take it very, very seriously.
I'm totally confident with that. That's not the issue. My issue is, you look at the court system, every other chief judge is a time limit. What, 5 years usually on all chief of the district court, chief of the juvenile court, and they have to come back and either be reappointed and I'm sure, you know, you get input from different judges in that court as to how a chief is handling it. But every court we have has a chief that only sits for 5 years. Judge Carey sits for a time limit. Chief Judge of the Superior Court. The Chief Judge of the SJC is the only one that doesn't do that. So.
But I don't think they have to come before you to be chief of their courts.
No, they don't. And you wouldn't have to go before us again. I'm not saying that. I'm saying you would have to get some vote of confidence from, let's say, the other SJC judges.
They give me their input every single day.
Yeah. So anyway, it's a thought. Let me ask you about just briefly about a couple of cases. that I know you're familiar with, Commonwealth versus Rosario.
Yeah, that was a case that I did during the first court term that I was there. And
so my question in it is, the usual we hear constantly in this business of interrogations that are fraught with issues. In this case, the defendant was forced to sign some documents. He didn't speak English. And one, according to a translator, he wasn't even shown the document that he signed. It wasn't read to him. And you pointed that out as problematic. My question to you is, with today's technology, why isn't every single interrogation taped and audioed? I know you did a case where you said you were recommending it for murder cases, but that, I think, in my own view, is recommending that has never worked. Yes, they do it in murder cases sometimes, most of the times. I'm talking about other serious felonies. I'm talking about whenever anybody goes in for an interrogation. It is so easy today to do that. And we spend more time fighting in courts over what was said in a room. And, this was said, no, it wasn't. We go back and forth on these motions to suppress, and it would cut out all of those if every single case was put on an audio and a video.
I agree. I think that a lot of police departments are doing that as a standard. And if they don't do it, they don't get the benefit of the doubt about what they said happened.
Yeah, but it's so hard in a courtroom without a video. I mean, nobody's getting up on the stand and saying that they did this terrible thing to the defendant and made him confess. It's not ever going to happen.
Yeah, and just to be clear, in this case, this wasn't back in the 80s.
Right.
Yeah.
Right. But it came up.
Absolutely.
Before you. But that's still happening, those things. And you hear from your client saying, this is what happened in the room. The DA says, no, it didn't. And now we're into 3-4 hours, sometimes more hearings, cross-examining the police, when we don't have to do that if everything was recorded. And today, I assume right now, and everywhere I go, there's a video of me.
Right.
And I think the only place there isn't a video is in these interrogation rooms for some reason. So I'd ask you to kind of think about that. It would just save so much back and forth needlessly. And I know some police departments have cameras in the cruisers, what they call them, grill cameras. They show people doing field sobriety tests. It cuts out so much argument when you see it on the video. It either helps your client or it doesn't, but there's very little argument over it.
Yep, I agree with you. I'm not sure what the court can do.
Well, you can order it.
Well,
You ordered it in the, what was the name of the case? Di Benedetto. You ordered it saying, we suggest. Well, now the court can say, this is no longer a suggestion. This is going to be a court order. If you're interrogating a defendant, it's audioed and recorded. There isn't a police station in this Commonwealth that doesn't have that equipment. Even if they interview him in his own house, put it on a cell phone.
Yeah.
And not only would it save a lot of work, it would be fairer. It would cut down on these allegations that the police were heavy-handed because it wouldn't be on the video if it didn't happen. anyway, that's my take on that. The other issue is body cameras. I don't know why every police officer in this Commonwealth shouldn't have a body camera on with what's happening in today. So, I mean, I think you on the court up there can have these cases that you can say, we're ordering it.
If we get a case that has those facts, I'll certainly take a look at it.
I'll try to get one.
Okay.
The next case is the Williams case, where there was an issue with the juror.
Yes.
Remember that case?
I do. I do remember that case.
And
Mary, right behind you, worked on
I got a kick out of the decision because the juror says, it's a black lady. She says that she's asked by the judge why you raised your hand. And she says, yeah, I work with like low income youth in school setting. I work with a lot of people who were convicted of like teenagers who were convicted of drug crimes. And frankly, I think the system is rigged against young African American males. If I was a judge, I would immediately make her the jury foreman, because not only was she honest, she was the only one telling the truth in that goddamn jury, as far as I'm concerned. But anyway, the judge said, you think that belief might interfere with your ability to be fair and impartial? She says, I don't think so. And I think the decision was she wasn't more certain of her answer. The judge says, you think you can put this aside? She says, I don't think I can put it aside. And he says, no. And she says, look, the lens that I view the world through, I think I can be unbiased. I think I can be. I think I can listen to the evidence. And she says, again, I think so, when asked by the judge. And your order indicates, your finding indicates that the judge should have went further in exploring that issue with this juror before he threw her off for cause. But you know, when somebody's asked a question, like I ask you, do you think you can do this? The natural response to somebody is, since you brought up the word think, I think I can, or I don't think I can.
That's right.
But in this case, it seemed that answer was not certain enough. Although she was responding to the judge's think question. Anyway, let me ask a question. General question, philosophical question. Do you think the day of jurors, the way we pick them, should be reconsidered?
Say more.
And do you think that we should have professional jurors? There's a lot of research been done on that topic. And having a group of jurors who got a stipend for sitting, but they were professionally trained by the court to be fair and objective. And if they didn't fit certain criteria or testing along the way, they got booted out of the group. To make the finding without emotion or those kind of things. And at least try it to see if it works better. Because to me, jurors are really an unknown quantity. They can decide guilt for any reason they want. And we never know sometimes what they decide in their own minds or why. And I just think we ought to think in these days anyway, that maybe taking a look or doing a pilot program for professional jurors that have to meet certain criteria to sit.
It's an interesting idea. I'm a little skeptical, maybe only because this is, I'm.
How can we
I
do
grew
any work?
up doing jury trials, picking people from a cross-section of the community, coming from all different backgrounds, bringing their own experiences, and it's not perfect, but I think it works most of the time.
Well, that may be the problem. I read yesterday, a fella in Boston here did 41 years state prison for a crime he didn't commit. And how many times have we heard those stories?
No question.
Statistics say 15 to 20% of jury verdicts are wrong. That's a lot. And when you're dealing with somebody's freedom, you imagine how hard it is to be in jail when you committed the crime? How much harder it is when you didn't commit that crime? 41 years, and I think the fellow was from Springfield.
Can't even imagine.
Originally. And his son was with him and said that he was like 2 or 3 years old when his father went to jail and he never saw him. But I'm just thinking that maybe if the jury was a professional jury, maybe they would have less mistakes than the jurors we have now. I'll tell you one thing. I would never want to sit in front of a jury. Never. Because you have no idea how they're voting.
Right.
They may not like your looks.
That's right.
They may not like your lawyer's looks. But to me, that is no joke. That is leading it to people that can take your freedom away, and then 10 years later, or 20 years later, oops, we made a mistake, sorry, you can go now. Anyway, that's something I think we should take a look at, because we seem to be, with DNA now, more and more people are being shown. And don't forget, during that trial, wherever it was, an assistant district attorney stood in front of a jury and pointed and said, he's the man that did that killing. That killed little whoever, and pulling at the heartstrings of the jury. So anyway, that's an idea. The other issue I have on jurors is grand jurors. My question philosophically is, why do we have grand jurors anymore? They seem to have lost any sense of relevancy. I had over the years, I've had probable cause hearings. I haven't had one, I think, in over 20 years now. About a month ago, I was before a judge and probable cause hearing. The assistant district attorney, who's a great guy, he said, Judge, we're not ready. We're sending this up for an indictment. We're not ready. And I said, well, Judge, I said, I'll say something about my friend's comments. What he means to say is, we're never having a probable cause hearing. Ever. And I said to the judge, you probably have never had a probable cause hearing. I think the judge had been sitting about 5 or 6 years. You probably never had one since you've been on the bench. We are not going to have any probable cause hearings unless the DA wants a judge to have it to get rid of a case that he doesn't want to touch. So it seems to me, if there's a probable cause hearing on the books and we're supposed to have them, then we should have them. I was encouraged somewhat being up in Lowell about 2 weeks ago where I had the same situation. And the judge said to the DA, why aren't you ready? And he said, well, we don't have the ballistic expert. And he said, well, you don't need that for probable cause hearing. So he said, what I'm going to do is dismiss the case as it has to do with anything that would be going to the Superior Court. So he cut out a bunch of charges and left it in. And that was the first time I've seen a judge do that. And I don't know how many years. So the question is, you know, we got grand jurors. If we're going to have them, my suggestion is we have court lawyers that handle the grand jury. And we get the district attorneys out of the grand jury. So there's no question of what went on in the grand jury. Because the old joke is the DA could have died a ham sandwich. I don't think that's too far off. So to me, either we make grand jurors relevant for what they were intended for. And the only way I think you can do that objectively and give a sense of transparency is to have lawyers that work in each county for the court system that handles the grand jury, gives the grand juries all their rights, what they can do. They can hire an investigator if they want. They can do all these things that they're never told.
Yeah, I mean, the only problem with that would be separation of powers because it's up to the executive to bring the charges, so the judiciary can't get involved in that. But I absolutely understand your concern.
Well, it seems to me it's okay. The other case I had was I had a case. I don't think it's on your list. It was Commonwealth versus Rogelio Buckley.
Buckley.
You remember that?
Yeah, I think so.
And it was an inventory search, an automobile. No, strike that. It was not. That was my notes on asking you a question. But it had to do with a traffic stop. And there was a passenger in the passenger seat. Yeah, he got out of the car and they found a gun under the passenger seat. My issue with the case was let me ask you this. Do you think what we call the war on drugs has been successful? Just personally.
I don't know that, I'm not sure anybody thinks that anymore, do they?
Our court system.
Well, when you say the war on drugs.
I mean, we have been fighting this for 50 years, trillions of dollars, and we are still in court. It has wreaked havoc on our rights under the Constitution. How many cases are drug cases, search warrants and all of that?
You know,
it's gutted our rights.
It's a problem. It's a problem.
It's led to massive corruption by everybody that's involved in the system with drugs.
Yeah. I wouldn't characterize what we're doing now as a war on drugs. There are laws on the books that are being prosecuted.
Yeah.
They need to look at those laws. They need to look at the sentences that result from convictions. There's a lot of things that need to change. But I think that what started in the 80s, it's not quite what's going on now. There's no question. There's a lot that needs to be fixed.
It's led to the incarceration of hundreds of thousands of people. And more than half have been minorities, much more than half.
It has a disparate impact for sure.
Yeah. What do you think of inventory searches?
In what respect?
Whether it's abused too much.
Unfortunately, I mean, the rule is if you're going to take the car, you get to look to see what's in it before you take it.
Why?
In order to make sure that they don't, they don't get accused of having taken something out of the car. I mean, that's...
Okay, but for that, these have turned into, in my opinion, nothing but a pretext to search.
So you have to look at why you're taking the car in the first place.
I mean, okay, let's say an individual's car is taken and he makes a complaint that this is missing or that's missing. Isn't it better to let that play itself out in whatever forum than to open up an avenue for unfettered searches of every single car that they're going to put under. They're going to arrest the defendant. They're going to search his car for the inventory.
Again, I think searching the car is something that you have to decide whether you're going to take the car, and that has to be reasonable.
The next case is Haywood. A blind juror sat on the trial. And I've had that happen to me in a jury.
How'd it go?
Well, it didn't go good for my client, but what happened was, I think, because nobody, I don't think, including the judge who had the case or anybody involved, the DA or the lawyers, there was another lawyer too, we had never had that happen to us before. So I said to the judge, well, we're going on a view. He said, yeah. So he thought about it and he said, well, I'll have one of the jurors tell the blind juror what he sees. I said, well, how do we know what he's telling him and the slant he's putting on what he's telling him? How do we know that? So anyway, we went through with it, and there was evidence in the case, pictures and stuff like that, and he had a juror tell the person what he saw again, but you don't know nobody heard what was said. So we didn't know whether he was telling them, hey, look, this picture definitely is convincing that he did this or something, or the other side too, you know? So I think there's got to be some control over that as to what's being told to this particular juror.
I agree that there need to be standardized procedures. In this particular case in Haywood, photographs were not really germane to the question to be figured out. But if there's something that does need to be seen, I think you've got a reason that a blind juror wouldn't be qualified to serve on that particular case.
Or maybe the defense lawyer and the prosecutor should tell the juror together, the three of them, talk about the pictures.
And that's
each give a
certainly a
slant.
way to do it.
But to have another juror do it is like, geez. Okay. The Claudio case. It involves the Farouk scandal out in Amherst. Have you read Judge Carey's decision on the Farouk case?
Out in
Springfield?
I'm familiar with it. It's been a couple of years. But I know that he made some findings that were...
Let me read just a few remarks he's made in a couple of pages here. And the reason I'm reading it is because I've never in my career, 42 years, ever seen anything in writing like this by a judge. He says, that the defendant's more controversial allegations is that the Attorney General's office committed egregious governmental misconduct by withholding from them exculpatory evidence about the scope of Farouk's misconduct. He says the Attorney General's office patently baseless defenses for its withholding of exculpatory evidence. Most recently and surprisingly, in 2017, the Attorney General's office denies having had any legal obligation to turn over the mental health worksheets to the district attorneys, because the Attorney General's office had not prosecuted the drug lab defendants, even though they were part of the case. That position is at odds with the fundamental principles of fairness, the duties of the prosecutor to administer justice fairly, and particularly concerning requested or obviously exculpatory evidence, goes beyond winning convictions. Equally groundless are the Attorney General's assertions that it had a good faith basis for believing that the mental health worksheets were privileged. Were that true, the Attorney General's office should have given them to Judge Kinder as ordered in September 2013 for an in-camera review and determination of what should have been disclosed to the defendants. And that was in Springfield, where Judge Kinder had ordered the file to be turned over to him. Unfortunately, he received a letter from one of the assistant attorney generals saying, "I've looked through the file and there's no exculpatory evidence." And he took that at face value, which he shouldn't have done in hindsight. Instead, the Attorney General's office deceived Judge Kinder into believing there were no privileged documents for him to review on the ruse that the Attorney General's office had turned over all of the documents. Foster, who was the other assistant attorney general, Foster's letter essentially violated Judge Kinder's order. The Attorney General's office contention that it had a good faith basis for believing that the mental health records were privileged is further belied by Kaczmarek, who was the other assistant attorney general. Notation in her prosecution memo that case law suggests that the mental health worksheets were not privileged. Despite the drug lab defendants' diligent discovery efforts, Kaczmarek and Foster managed to withhold the mental health worksheets through deception. They tampered with the fair, just administration of justice by deceiving Judge Kinder and engaging in a pattern calculated to interfere with the court's ability, impartiality to adjudicate discovery. Kaczmarek and Foster's misconduct improperly influenced and distorted Judge Kinder's fact-finding and legal conclusions and unfairly hampered the defendant's presentation of evidence. This conduct constitutes a fraud upon the court. Moreover, the misrepresentations did not stop in 2013. I do not credit Kaczmarek's 2016 testimony, relied upon by the Attorney General's office, feigning that she forgot about the mental health worksheets and erroneously assumed that they had been turned over. Mental health worksheets were the subject of repeated communication to which Kaczmarek was a party in 2013 and were chief reasons that she sought to block the defendant's discovery. Kaczmarek knew the mental health worksheets were exculpatory admissions by Farak, and the drug lab defendants were entitled to them. At every opportunity, Kaczmarek and Foster foreclosed the defendant's access to mental health worksheets, compounding Kaczmarek's misconduct and Foster's misrepresentations was Foster's inexcusable failure to undertake any review of the discovery despite unequivocal directives to do so by Kinder and Reardon. Kaczmarek and Foster's conduct is reprehensible and magnified by the fact that it was not limited to an isolated incident, but a series of calculated misrepresentations. Had the Attorney General's office made timely disclosures of the mental health worksheets, many of the defendants before me now, as explained below, would have obtained discovery to support their claims for relief and would not have spent as much time incarcerated. How do you stop that?
So I know in Claudio, I described the conduct of the prosecutors, and you know, over 24,000 cases were thrown out as a result. We did what we could when we found out what, and it got to us.
Yeah, no, I'm not troubled by the court, but to me, anyway, and most of these defendants, people of color and other minorities, and they stayed in jail I think for another 14 or 15 months until Judge Carey got involved with this and issued his order. To me, if you do something like this as a prosecutor, and you cause somebody to be in jail for that much time when they shouldn't have been, my opinion is you should have to do the jail time that they had to do. And if that were the case, this would stop. This would stop. Because it doesn't seem to me that there is any necessity for, and it's a minority of prosecutors, believe me, but there's no incentive for somebody who thinks like that not to do it. Oh, yeah, this case is different. They got caught and they got embarrassed. But they didn't pay much of a penalty after that. I don't even know today whether they've been finished with at the Board of Bar Overseas.
I think it may still be winding its way through,
Yeah.
and it may end up before us, but that's the only reason
Yeah.
you can understand why.
But even that, there's people that went to jail, that stayed in jail for 14, 15 months because of this terrible action by these individuals. And to me, the only way you stop it is by, if somebody does something in our system that causes somebody to go to jail unfairly, then that's a penalty you pay for doing it. And then it'll stop, I think. And I don't know that one. You didn't sit on this case, but it was Commonwealth versus Henry. You were that case that Judge Gantz wrote a wonderful opinion about it. It had to do with restitution and not being forced to pay restitution if you couldn't afford it.
I'm not familiar with
Yeah,
that.
so he said that you can't make as a judge an order for restitution if the defendant cannot pay it. And you can't be violated on probation if you can't afford to pay the order. He also said that the order of restitution shall be determined by if it's stolen from a commercial place like a store or something, not the sale value, but the wholesale value they paid for it. And it's caused a lot of griping by people that say to me, well, now people can steal whatever they want, they don't have to pay it. Well, it's probably true, but Judge Gantz, and I thought a very well-written opinion, he said, look, why are we chasing people and putting them in jail because they can't pay, they don't have the money to pay? And we're doing all this work, but we're never going to get the money anyway, the restitution. But anyway, I thought I'd bring it up because it was a great case for Judge Gantz. What else do I got for you? Oh yeah, my little thing here. And I believe last time you were here, you and 4 other nominees for the SJC said that it would be ineffective assistance of counsel and malpractice to waive a jury trial before you knew what judge was sitting in the courtroom when you were at. And it has to do with this jury waiving cases, and more often than it's really a district court issue. But we still have judges that want somebody to waive the jury, and then they're going to have a trial in a month. But they have no idea what judge they're going to get. And although I love all the judges, some of them have never said not guilty in the entire time they've been on the bench. So I would not want a jury waive with one of those judges, obviously. You go to the jury. And even the form, it's called a pretrial conference report. Judges say, I want to get that filed. Well, you don't even know what day you're coming back on the jury. And in it, on the back page, it says, case information, parentheses, binding. with jury, jury waived. And then in parentheses, it says, prepare jury waiver from the court. Right then and that, when you sign this. So what I write on it, and nobody's yelled at me yet, I write, unable to make that decision at this time.
Smart.
But my question is, why is it even on here? Binding, what does that mean? And it's not judge shopping, because when I am in a court, or Councilor Kennedy the same way with this stuff, and you say, okay, I'm going to put it down for trial, Judge. And he says, well, jury waived. I said, I don't know. It's not judge shopping, because I don't know who I'm getting when I come back.
Right.
And even if I look at some schedule that's hanging around for a month, they're month schedules, and it says, Judge so-and-so is sitting on this day. When I get there, he may bang in sick. He may be in another courtroom that day, not in the one he's supposed to be in. So, but again, we have this form that, and some judges, they stick to it. And they want to take a jury waiver. You're going to come back in a month. I agree with all you judges in the SJC that said it's malpractice, and I cite that to judges.
Is that right?
I said, I don't want to commit malpractice or ineffective assistance. So anyway, I would ask you to look into that and see if you can get this foolish binding thing out of the way.
Sounds like you figured out how to get around it.
You can, but if, I don't want to get into a beef with the judge. He holds me in contempt, and then I have to call the SJC to get me out of jail.
Fair enough.
Do you think we have racism in our courts?
Yes.
It's been a problem for a long, long time.
Since before the country was founded.
Right. So are judges now sent for mandatory training with regard to that issue?
We had a all-court conference back in 2015 or 16. It's time to do another all-court training, but there have been, our Flashner Institute has programs all the time about implicit bias. We had Dr. Ibram Kendi come to speak to us. He's in charge. He's the new, they've got a new center for discrimination bias studies at BU. He came to speak to us. We've got a lot of programming. It's not mandatory. And obviously it's important for those who aren't quite convinced that there is discrimination for them to be educated. We're trying to get there.
Who makes the call as to whether it's mandatory?
Well, first we have to set something up, and the SJC would probably make that call.
Yeah, I would strongly suggest we do it quickly rather than later, because there is racism in our court system. And people are being hurt by it.
Yeah. I think a training by itself isn't going to do it.
Maybe not.
But I'm not disagreeing with you.
But it's
I
a
think
start.
it's important. It's part of what needs to happen.
And training not only for every judge, but for every judge to be on the lookout when he or she sees it and say something about it.
Yeah. You know that there are implicit bias committees on every trial court, and they're working on these things locally on the ground. So
here's something that I think is one of the racist issues in our court. We represent a person from a minority community. And by the time he's 20, 24, 23, if you look on his record, and he has no record, it's unusual. It's a rarity. because people in minority communities interact with police much more so than, let's say, the young people in a town like Long Meadow or Wellesley. And their interactions usually end up with some sort of an arrest and charges. So to me, and I ask this question rhetorically, I know the answer, why do we look at somebody's record? Why does a judge look at somebody's record? And I'm used to it from when I was on the police, and I'm used to it for 42 years in the court. Something we do all the time. But lately I'm saying, why do we do that? Because for the minorities who are getting nailed with charges and crimes at a much higher level than non-minorities, now a judge looks at a record and says, oh, this fellow's got 5 things in his record. I'm going to have to punish him more now. So I don't think it's fair, first of all. And I always was under the impression that once you committed some crime and you served your time or you did what you were supposed to, you paid your debt to society. That may be okay for society, but it's not for our courts. It's used against people all the time, and it affects minorities much greater than non-minorities. Why not just sentence somebody based on the crime they committed? It's like what the court system now does, I hear, the progressive discipline for employees. Well, that's what we do to defendants, I guess, by looking at records. The more he has, the more we punish. Doesn't matter why the first crimes were there. Well, he pled guilty. Well, of course, most people plead guilty. They don't take the chance of getting punished more harshly by going to trial. So I think that should be done away with. Just me. I think it has its origins in a racist tent whenever they started using that. So I don't think you've changed your opinion from when you were last here about 3 things: death penalty, same-sex marriage, and women's right to choose. I don't think you changed your mind on that. So I won't ask you on that.
Fair enough.
Okay, so I think you've done a great job as an SJC judge. Wonderful job.
Thank you.
And I think you're what's needed for the top job today. And as I told you, I am not going to vote for you anymore after this vote, okay? So if you're going to go to another court,
okay,
I'm not going to vote for you.
Fair enough.
All right? I wish you well, and I know you'll do well.
I'd like to call on Councilor Iannella to question the nominee.
Thank you. I don't have many questions. It was nice to talk to you a few days ago. Let me say from the outset, and I told you this, an outstanding appointment. I think you're going to do a great job, and I'm looking forward to voting for you next week. It's so good to see your father here, your family, your son. What a proud day. And I'm really proud. I will be proud to vote for you next week. But just a couple of quick questions.
Of course.
Status of jury trials in Massachusetts.
So we are hoping to begin very slowly rolling out jury trials in the next couple of weeks. And when I say slowly, a couple of different courthouses that meet the standards, 6-person juries, 1 a week in each of the courthouses and see how it goes. With the uptick in cases, we have to be very careful. We're not going as quickly as we'd like to go, but we have to figure out a way to do this without causing a super spreader event.
Now, when you say 6-person juries, you're talking this criminal session, the civil session?
We're going to start with civil cases.
And this will be in the district court and the superior court?
Definitely. I don't know that that's all been ironed out yet. I know district court is talking about doing it. I know that there are places, some district court houses. And I'm not quite sure where we are. I don't think that there's going to be a superior court case in the first pilot program, but it's being contemplated.
So at this point, no, we're not going to reduce the jurors from 12 to 6 in the superior court. We're going to hold off on that.
So, right.
Okay.
Nothing's been decided about superior court.
Let me ask this question. Let's assume a lawyer or whoever, litigant, says, I don't feel comfortable because I know this council and the lieutenant governor, people can meet, but most of us do it by webcam. The lieutenant governor and me as well, many times don't show up. So let's assume a jury trial is scheduled in the so-and-so district court, and it's my case. And if I ask for a continuance, do you expect that to be automatically granted because of the COVID situation? Some people, I have asthma. Other people have other medical issues. What type of, I'm concerned about how easy is it to get a continuance under these circumstances?
I think there's going to be a case that we're going to be hearing about whether people have to come in or, what the situation is. So I can't really speak to anything in particular right now, but I do know just anecdotally that you may know more than I do, but that judges will look at whether there's a necessity to come in, if it's depending on the type of hearing. And I think that people are trying to work, for the most part, things out. I know a lot of hearings are being done by way of Zoom, and that's working well. So,
are you suggesting that these jury trials may be done by Zoom?
Oh no, I'm sorry. I thought we were talking about hearings. No,
I'm talking about a jury trial.
Right.
Let's assume attorney so-and-so doesn't feel comfortable at all. Like the lieutenant governor and many counselors, including myself, don't feel comfortable showing up here. Despite the fact that there is social distancing, we don't like showing up. This is a real exception. Is it going to be routinely allowed? Because lawyers have asked me this, that a judge will grant a continuance, and what type of direction will you give these district court judges?
So I do think we have a case coming up next month that involves these issues. And so let's hear that case and decide it. And hopefully that will give guidance with regard to whether lawyers, what happens with lawyers. I think these cases have to do with defendants.
But again, lawyers have issues too.
For sure.
So I just want to be clear.
Well, practically speaking, you can request a continuance, and if that's not allowed, you can take the next step and
What's the next step?
Appeal it. Single justice.
No, I know. Okay. Do you think, again, I'm trying to get a sense because people are asking me, I'm in downtown Boston, there's a lot of people, they're asking that question. And I'm getting the sense, and with all due respect to you, I'm not getting a clear, I'd have to go back to these folks. I'm really not sure. They're going to decide that case somewhere in the future.
Yeah.
And for a lawyer who says, oh, gee, I got a case coming up January 23rd. Oh, my wife, my kids, this is too much. I can't do it. But I'm getting the impression from you is we're going to wait and see, as opposed to, I guess my question is, what's wrong with just saying the directive, if someone has an issue like that, continue the case? Why? That's what I would hope that the court would say. I'm
Sure.
talking
Yeah,
about
yeah,
directed from you.
Yeah, so you're saying if somebody has an underlying condition or they just don't feel comfortable?
Oh, no, well, like I have asthma.
Yeah, if you have an underlying condition, you shouldn't have to put yourself in harm's way.
Sure.
I agree.
Okay.
Absolutely.
Okay. Well, that's good
Oh,
because
yeah.
people have asked me that.
No,
Yeah.
no, I mean, everybody, the cases are going up, deaths are going up. I completely
that's my-
understand. Thank you for being here. No, seriously.
Yes, thank you. Thank you. No, but that's a concern that I've heard from people. Oh, do I have to try this case? Oh,
Yeah, so.
okay. And let me ask this. If I hear that it's not judges are forcing, no, you got to show up. Should I notify the court? Should I notify your office? Because that's a real problem. If something serious happens to someone's hospitalized because the judge here, the judge in this court or that court is forcing them to try the case. Is that okay? Did we notify your court?
I would notify somebody, especially if you have an underlying condition. Do not put your life on the line for.
Okay, that's good. Thank you. What about statute of limitations? What's the status of that?
In terms of
filings, they told what's going on with that?
Yeah, I think they're back up and running.
I think they're back up. My only concern with that is people have also told me, it's a lot of these courts, you just can't go up and file it. You can't get in. And it's funny, well, I don't know. People always call me. I don't know. They file it just like the nomination papers. Okay, I'm coming into that question, by the way, too. I didn't forget that. But just like the nomination papers, you file nomination papers, the post office. I filed some nominations for somebody, and I got it back 3 weeks later. Undeliverable. What are you talking about? Undeliverable. We got the right address. What happens in those situations? You file it, and you get it back from the statute's gone. And here it is right here. I got the Suffolk Superior Court. I got the right address. What do we do in those situations?
I think you can explain the situation and judges have the.
But who do we bring that? You said the judge. It's just filed. It's not even assigned.
Got it.
I got a piece of paper here. What do I do?
You talk to the clerk's office.
And they're going to say, sorry. What can I do? It's got to be filed by, November 3rd. Sorry.
Yeah. I would take it up the chain. I mean.
What's the chain, just so I can?
So I would say after talking to the person at the desk, asked to talk to the clerk of.
No, I got it. But they all say, no, hey, I'd love to help you, but what can I do? I can't change the statute date. The law says you're supposed to file it by November 3rd. If I allow it, the defendant's going to come in with a I can't do it. I'd love to do it for you, Chris, but I can't do that.
Well, I could say you could, again, file a 211-3 and try to get it heard by the appeals court or the SJC.
Is that something that likely would happen?
It's possible.
You say possible. That's almost like I think. Again, I'm not giving you a hard time, but these things could happen.
I understand.
Possible means it possibly may not.
But if you're saying because of the pandemic.
Oh, yeah. This is all about I'm sorry.
Yeah.
This is all about the pandemic. You can't go into court because, it's closed. And you file it and it comes back and undeliverable, whatever.
So if that happens, that's obviously a problem. And I would hope that people in the clerk's office understand.
But if they don't, I'm worried, like, how far up in the chain do we go?
Yeah.
Where do you go? Well, that's what I'm trying to get at.
What'd you say?
That's what I'm trying to say.
Yeah.
That's what I meant. Yeah. Okay.
Right.
Okay.
Take it to the top.
That was easy. That was good.
Thank you, Counselor Jubinville.
He's good. Now, my last topic.
Yes.
The case that you folks took up last April on the nomination signatures.
Mm-hmm.
The signatures, the nomination papers came out. First of all, this does not apply to me. I was unopposed, so it's not like I got an axe to grind, just so you know. The nomination papers came out, I believe, February 4th, 5th, 7th, give or take. And they would do, give or take, April 24th, 1st, give or take. I mean, you can tell me, what was your thought process, the court, in that? Because I can honestly tell you, a lot of people in the political world, the average citizen doesn't really care,
Sure.
were quite surprised at the decision. tell me your deliberations, your thought process in putting the signatures, like I think you cut them in half.
Yeah. Broadly speaking, because of the pandemic, the normal requirements for getting on the ballot, because people couldn't get out and about, it wasn't reasonable. Usually in regular times, it's perfectly fine. But because there's a right to be on the ballot, if you fulfill certain requirements, and those the time period was condensed, and it was very, it was, when things closed down, it was just difficult to do what you could normally do. And so we had to try to figure out a way to, it wasn't perfect, but we tried to figure out a way to adjust things so that we could account for what had happened with the pandemic. And that's really all.
Yeah, my concern was, the papers, like I said, came out February 7th.
Mhm.
You folks decided in late April, give or take. I was second. Juvenile was first. He got all his signatures in first week of March. I got all my I got more than enough that the Secretary of State wouldn't even count all my signatures. They really wouldn't. So again, it just did not apply to me. But if it did, I would have said, Jesus, I did it. He did it. She did it. He did. Like, come on. You have 2.5 months to get it. Why are you giving them more time? That's number one. Why would you give them so much more time? It's not like these people didn't know this was an issue. It didn't suddenly happen overnight. We knew mid-March that there was a problem. There's all different ways you could get the signatures, and then you reduced. How did you arrive at reducing it? Was there like, okay, let's do it 3/4, let's do it 25%? How do you come up with 50%?
I think it had to do with the timing and, how much time they had left. I don't remember specifically, but we tried to figure out a way to make it fair. There's no more or less to it.
The concern that I have, I think, and I think a lot of people think, and a lot of people disagree with me, that's the legislature writes the rules. The legislature sets the rules, not the SJC. And if I recall, there was talk, and you'd see it in the newspaper, that the legislature, and there were bills by representative, actually in my district, I forget his name, to reduce the signatures. So it's not like the legislature wasn't even thinking about it. They were thinking about it. Who knows what they would have done? I guess my first question is, what if the legislature had acted the day before and reduced the signatures instead of 50% to 25%? Would you still have taken the case and maybe or probably done what you did?
Yeah, no, we took the case because the legislature hadn't acted.
No, I understand that.
Right. So there wouldn't be anything. I agree. It's up to the legislature to make those, to put those statutes in place. And the only reason we acted, we were in a position where there is a right to be on the ballot. And there was a situation that the legislature hadn't acted, so we had to step in.
Okay, so let's take this coming June is, I'm from the city of Boston. I believe, the nomination papers for mayor of Boston and the city council. And let's assume this pandemic is unbelievable. It's getting crazy. It's, that'd be our worst nightmare. And unlike when us folks run for state office on the state level, we have several months to get nomination papers. I believe when my father and even my brother being on the city council, my understanding is that they have like 3 weeks to get the signatures. Let's assume, I don't even know who sets the, maybe it's the city council. I don't know who sets the requirements to get signatures. But let's assume that somebody, let's say city, whoever is supposed to do it, reduces the signatures from 3,000 to 2,900. And then on the, for city council, they reduce it from 1,500 to 1,400. So they acted.
Mm-hmm.
Okay, unlike the legislature did not act. Is that something, and they set the rules. Is that something that the court may take up again to say, oh, they didn't do it enough? They didn't reduce the signatures enough? Or is it a situation where, unlike the legislature, hey, this time the city council did something, maybe it's whatever. So I'm trying to get a sense from you. If you take that up again, like they didn't reduce it enough.
Right. It's hard to say what we would do without knowing all of the facts with the situations with the pandemic. But
same situation.
But I can tell you that we don't like to take over other people's jobs. We do what comes before us. And again, it would have been lovely had the legislature acted before we did. But time was going by. We had to do something.
Yeah, no, I understand that part, even though I disagree, but I totally understand and appreciate it. But I'm not, and I can understand it. If they had reduced it by 15% instead of whatever you folks gave, 2 weeks or 1 week, and if they reduced it by 3 or 4 days, you can't give me a definitive answer today whether or not what you would have done.
I can't but
same fact.
But I can tell you that it's up to the city council or the city of Boston to make their rules. And as a general matter, we let that be, you know. If someone brings a case, we have to take a look at it. If it gets to us, take a look at the facts and see if what they did was reasonable based on what's going on.
Sure. No, I understand. I guess there's a case that could hit the, we'll see. I believe the United States Supreme Court, well, I shouldn't say, they may decide, on obviously with what's going on in the country. There's a case out of Pennsylvania. My understanding is the legislature set the rules of, and don't hold me to this, I'm not, said all ballots must be counted by Tuesday, November 3rd at 8 p.m. The Pennsylvania Supreme Court changed what the legislature did and said, no, you have 3 additional days as long as it's postmarked. I'll be almost, not quite the same, but it's almost like in Pennsylvania, if it goes that way, they'll say, hey, the legislature sets the rules. In like this situation, you guys set the rules. So I'll be interested to see what happens in that. And if the Supreme Court does change that and says the legislature sets the rules, if I see you again on you're here for a witness or whatever, I will definitely ask you that question. What's your thoughts on that?
We'll take it up then.
But thank you so much. Again, it's going to be a pleasure. I think you're an outstanding candidate, and I wish you and your family the very best. Thank you.
Thank you so much.
Thank you, Councilor Ioneller. I'd like to now invite Councilor Duff to question the nominee.
Thank you, and thank you for being here, Judge. And I have to say, on behalf of the city of Peabody, my hometown and where you spent a good part of your life, we are extraordinarily proud of you. They did want me to ask you, you were number 2 in your class at Peabody High School. Whatever happened to number 1? I don't know.
It's a good question.
So anyway, I'm just teasing. But and on that note, I also want to share with the counselors that I think it was last year or the year before, I brought you and Justice Lowy, also a Peabody High graduate, to Peabody High School to do a forum with the students. And I received so much positive feedback. But the thing that was really stunning to me, and I've shared it with you, and I think I may have shared with your dad, but I want to share it with the Lieutenant Governor and the counselors. Your interaction with the students was, I was told by some parents, literally life-changing for some of them. I got emails and messages from parents, from one woman in particular who said, this judge changed my daughter's life. And you spoke to the students as someone who went to Peabody High, who probably didn't always have some of the same experiences that I had. And at that particular time, unbeknownst to me, they were going through some real racial issues in the high school. And you being there, your presence, and how you honestly spoke to those students, and I still remember one man's face in that audience. They had never seen anyone like them or heard anyone from their experience or close to it. And it was profound, and I thank you for it. And it is one of the reasons why I ask judges many times, particularly if you've gone to public school, to come back and speak to the kids, because it matters. It matters. And it's just a bonus gift to me that you happen to be African American. But the fact of the matter is you're sitting in the chair because you are the best person for this job. Bar none, hands down. And there was some stiff competition. So let me get that cheerleading thing out of the way and ask you a couple of questions. First, some things in your resume, I guess I'm going back to cheerleading a little bit. These are great. Some of your extracurricular work or pro bono, whatever we want to call it, is terrific stuff. I actually, through what our country has been through this year and continues to go, this trial court race and advisory committee, frankly, I would love, and this really isn't your responsibility, but this last sentence, our goal is to find ways to combat implicit bias through education and self-assessment. And boy, is that the truth. And I would love to see something like this, frankly, come to the Governor's Council. I think we can all do self-assessment, even people like me who think we're so, liberal and we know everything. This is really a time for a deep dive. And so off of this, I would love to talk to you about something like that, because I don't think we can ever have enough education. You're Changing Lives Through Literature program and work on that. You talked about that at your last hearing. I think it's tremendous. You shared with me a book that affected me so much that I was literally screaming when I was reading it at times because it was so outrageous, and that's Just Mercy. And you talked to the kids at the high school about that book. It's now become a movie, although the movie doesn't get into some of the really great parts, but terrific program. And thank you for being part of it. I will be asking you what else to read. I've never talked about this, but I do talk to the governor a lot about what I should be, or what he is reading, and we share books. And lastly, before I really get into the questions, your memberships are great. I don't know that if everybody here knows what all these things mean. I had the privilege of going to school in Washington, D.C., and one of the things that was life-forming and life-changing for me was the truth of the matter is I went to school with a lot of really rich people, and I was a middle-class kid. So I had a couple of jobs, and one of them was off campus, and this was in the 80s before we had the metro. And it was life-forming for me to, one, be the only white kid in my place of work, and many times to be the only white person on that bus. And it had informed me then, and it informs me now on how I see the world. And not everyone can have the experience I had. I was lucky, I was blessed. I've been blessed in my life through many, many things. But hats off to you and our new vice president-elect, because your sorority is probably the most powerful group of women in the country right now. Alpha Kappa Alpha. When I saw that, I know what these other groups are just because of, but that's, wow, good for you. Okay, to questions. Do you think, and these are not, I'm not about gotcha questions, I'm more curious on things of this. Do you think judges should be allowed to veer from the sentencing guidelines? And do you think if they don't go by the guidelines, that the sentence they give should be upheld?
Yeah, so the sentencing guidelines are just guidelines. They're not, they're not something, they can be used as a tool. Not everybody uses them.
Right.
They give you guidance. So yes, I think that a judge should look at what the circumstances of the case are, look at the defendant who's sitting or standing before him or her, and fashion a sentence that makes sense.
Okay, great. My next thing is, and Council Jubenville touched on some of this. We know that we don't get enough money in the courts. You and I had a conversation about that. One of my big issues is the community courts, and I don't believe we have access to justice if we don't have community courts, because we don't have a great public transportation system. And if you can't get to court, you don't have access to justice. And it really impacts lower income people more than anybody else. I live in Gloucester, Massachusetts. Now, I thought it was a peninsula before I moved there. I've learned it is actually an island. There are people who don't leave the island. And it's a real thing. And our community court is old school. We're upstairs from the police station. And so it's a completely different feel. I really tortured Governor Patrick to keep that court open. And I think I really did torture him. And I'd like to hear a little bit of your views, and I don't want to do a deep dive. You and I talked a little bit about it, and I think it's more of a conversation for later about, some of the mechanisms of how we do this, but a little bit about your philosophy and thoughts about the community court system and their role to play in Massachusetts.
I believe that community courts are very important. It's important to be able to get justice close to where you live. And I know that there are competing interests, and we have built justice centers that have several different courts in a hub.
The hubs.
That makes it difficult for people who don't have transportation to get there. And that without question is an access to justice issue. I think that given the move to virtual hearings because of the pandemic, that there may be a silver lining there because people are able to have their hearings without needing to come to the courthouse. And so I think that may be one of the ways we can tackle this issue. Again, not every hearing, not every thing that you have to do at court is something you can do virtually. But it wasn't something we were doing before the pandemic, and now we really, are using that technology.
Yeah. And I think it's, this pandemic is a horrible thing, and it's exploding right now again. But I think you really touched on something. There are lessons here for us to how do we use technology, and aren't we lucky we have it to do. What do you see the biggest challenge facing the judiciary in the next year? And do you have any thoughts on how to tackle that?
Right in front of me is the pandemic, and trying to make sure that the courts are running as they should to the extent that they can. So that's the immediate issue. You may know that we're also looking for a new court administrator and a new CIO. And so those are things that we've got to get in place sooner rather than later to get some of the things that the trial court wants to get done, including, the technology, the e-filing, things like that. Beyond that, like I mentioned to Councilor Devaney, the chief was involved in so many different projects, and I need to take a look at that. I'm not Superwoman. He was Superman, but I'm hoping that we can figure out a way to keep those things going. They're very, very important. But if we can get people involved, more people involved, in making sure that those programs stay up and running, they're very, very important. And obviously, racial disparities in the system is something that I'm concerned about and want to continue to work on.
Terrific. Yeah, and I think the upcoming task for the SJC to hire the next administrator is huge. And frankly, you're quite brave to want to step into these shoes right now, because there has probably, I don't know, some of the others here probably know better than me, but I don't know that there's ever been a time in our court history where we've been dealing with the pandemic, with filling a chief justice, 2 other seats on the court, and then we don't have a court administrator. Plus, we need money. We need money. Can I say that again? We need money. And how to get that. And there never seems to be enough to go around. But, I always say the day anybody appears in court is the most important day of their life. And it doesn't matter what they're there for. It doesn't matter if it's an estate, if it's an OUI, if it's a divorce, whatever it is, it's important. And I think your reputation of not just your academic brilliance is not surpassed by anybody on the court. I'm sure maybe your dad, but but also you have a wonderful reputation for fairness and for listening and for congeniality, and that's something that Justice Gantz really was able to do, to bring that gel to the court. I think your challenge is going to be tremendous. You know your colleagues. I don't think that's your biggest issue, but I think it's for the role you're going to have as a leader, leading and walking through this. I'm really glad it's you. And I think you have the skill set for it. One last question. How do you like being on the SJC?
It's an honor.
Yeah.
To be able to serve the Commonwealth in this way and to have a seat at the table and weigh in on issues that haven't been decided before. I take it very, very seriously.
I know you do, Judge. I have many pages of things I could talk about. And I'm Italian and Irish, so I could sit here and run my mouth for a long time, but I'm not going to bore people with that. I know we're probably getting close to a break, unless we'll go right to Kennedy. Thank you for your application. I was, as you know, excited about it. And, Godspeed to you. We need you. We're counting on you. No pressure. But we are also here to help and support you. I think many of the governor's councils have said many, many times in many, many hearings, we do feel that we should be helping get money out of this legislature a little bit more. And so make us do it.
Okay. Thank you.
Okay, thank you to the counselors for your questions thus far. I suggest we take a break to give Justice Budd a chance to stretch your legs and everyone else, and also join in the tribute to Justice Abrams that begins at 2. Have a little lunch, and we will resume in this room at 3:15. And what I'd like to do is have Councilor Kennedy, Councilor Hurley, and then follow-up questions from the counselors as needed. Okay, thank you. We recess until 3:15.
Hello? Am I back on?
Okay, we are back together here in the Great Hall. And we said we would resume this hearing at 3:15, and we're pretty much on target. I'd like to now turn it over to Councillor Kennedy to question the nominee, and then we will turn to Councillor Mary Hurley.
Okay, we're going to be done soon. I've already talked about the things that I'm going to discuss with you. You know, this isn't a gotcha moment. It's important just to get the information out, and it's important that you know that what people are going to talk about ahead of time a little bit. And the thing that I raised with you that I think is the most concerning, as it is all over the world, is the COVID issue in the courts. Okay. Counselor Juvenville and I are probably the people in here who spend the most time in court. I know Counselor Ferrara goes sometimes, but we spend the most time. I've been in court almost every day till COVID hit of my working career for 37 years. We have some incredibly hard-working people in the court system, whether it's the judges, the clerks, the staff, the custodians. They've done some incredible things in a very short period of time to try to get things moving. If people told me 9 months ago I'd be doing things on Zoom from my office, a lot of court matters, I'd be saying, what's Zoom? Yeah, but I am, and we all are. And you got up to speed pretty fast, the whole system, and they're to be commended for that. That said, there's a lot of issues. The biggest single issue I have is the lack of consistency in terms of protocols and how they're handling it in the courts. There is no consistency from court to court. Everybody has different rules. Middlesex Superior Court has different rules than Suffolk Superior Court in terms of when you go on Zoom, if you're on Zoom, if you have to be live, if your client has to be on Zoom, or if your client's appearance is automatically waived unless there's an issue. And it creates a lot of confusion. That's number one. Number two, I'm going to go through them and then you can address them one at a time. There's big issues about court closures when somebody tests positive. I gave you an example of a district court where somebody tested positive on a Monday about 2 weeks ago. They closed the court 2 days for cleaning. And I got to tell you, people think there's some company going in and doing a super cleaning. That's not the case. It's the courts that work hard that'll do a cleaning, but they're not trained for what they might need for this. Then that court did their 2-day closing, did their cleaning, opened up the next day, and the following day they were closing again because another person tested positive. And the problem with the 2-day closing is, as we've learned over the last 9 months with COVID, it's not so much about surface contamination as about contamination through air and breathing. And the people who tested positive, one was a police prosecutor, another person was somebody in the court's office. In this particular instance, they've been around all those other people. Everything I've read says that everybody who's been around someone who tested positive should be quarantining for 2 weeks. And that's not happening at all. They're closing for 2 days. They're reopening with the same people in there. And that just doesn't endanger potential litigants or lawyers coming in there, defendants. It also endangers mostly, because they're the people that are mostly in there, all those hardworking court people. How would you address that, and how would you address the lack of consistency in terms of how courts are handling it?
Okay, thank you, Councilor Kennedy. Before I answer your question, I just want to make sure that I tell Councilor Ionella that I found out during the break there will be jury trials in Woburn in Superior Court along with the other district courts, so absolutely.
I was going to ask you some more questions about jury trials as well. But
Okay, all right,
yeah.
one at a time. All right. So in terms of when cases or when hearings are going to be on Zoom and when they're not, when, who's going to be there, I think it really does depend on the facts and the situation, with the type of hearing and whether the person's in custody and all of those.
But that's not my question.
Oh, okay.
My question is that right now, I'm getting to that.
Oh.
My question right now is the lack of consistency in terms of how courts are handling this pandemic and when they close, when they don't close. I get on the Stoughton court, I go up to the window and I talk to a court officer who checks me in, and then I go sit in my car till I'm called. You go to another court, you can just walk in.
Yeah.
When they close, some courts will close for 2 days, some courts will close for 2 weeks. when someone tests positive. And the person who's making that call is usually the presiding judge, who's not trained to make that call. And they get the guidance that you people give them with standing orders, but they're not getting any information from scientists.
Actually, I did look into this, so I appreciate the question, and I appreciate you telling me ahead of time. There is a protocol that they go through. Chief Carey and the court administrator, they are consulting with the DPH. They have an epidemiologist that they consult with and a building specialist. Now, I can't speak to why the court closes as opposed to worrying about, who. I don't know about, I'm not an expert either. So here's
You're going to have to become one.
Well, here's what they do. They do a contact assessment and see where the person has been and how many people.
It's not happening.
Okay, well.
It's not happening. I can tell you because I get complaints about that.
Okay.
They're not taking contact information from people going in the court.
Mm-hmm.
They're not taking it from lawyers. They're not taking it from defendants. When I go to Tony C's restaurant across the street, they take my name and telephone number for contact information in case somebody tests positive. The courts aren't doing that.
So maybe that's where there's a problem. And so
that's one problem.
I'm not sure how people get notified, but it sounds like that information needs to be used in a different way.
People are not getting notified. That's one of the problems.
I mean, if the court, somebody in the courthouse finds out, obviously, because then somebody has COVID.
The way people are getting notified is a lawyer will find out. It'll end up on a CPS website or something like that. But for the rest of the world, they're not getting notified. They're not taking contact information. I've been told that they don't do it because they're afraid it's an invasion of privacy. So they're not getting, I'm just telling you, it's not happening.
I'm not sure that, I think what I meant is that they try to contact the people that the person who has been tested positive, it's self-report. So the person who has tested positive says where they've been and who they've come in contact with. And the period of time is 6 feet away for 15 minutes total, right?
Right.
So that's the criteria. It's not just people that you pass in the hallway. So they try to contact those people who they've spent that period of time with.
Nobody's keeping track of that.
Okay. Okay.
I don't expect you to be able.
I mean,
I don't expect you to be able to solve that problem right now. I'm just telling you, it is not happening. I go to court. I see what's happening. I hear the complaints from people. I get panic calls from lawyers saying, "Hey, why aren't they doing this? Why aren't they doing that?" And it's just not happening. And but aside from that, it's the lack of consistency in terms of how each court handles it. Not just in terms of the shutdowns, but also in terms of, I called the list in Suffolk Superior Court 2 weeks ago. Where's your client? Well, I told them not to be here because that's the way everybody else is doing it. Well, that's not the way we're doing it here. And that's not being communicated either. And I think that the one thing that should come out of this is that there should be consistency. If the rule is the client's on Zoom with you, the rule is the client's on Zoom. If the rule is that the client's appearance is waived, that's the rule. Depending on what the event is, maybe, but there's no clear guidance for the bar at all.
I hear the frustration, and I completely understand. And I know, everybody's sort of trying to figure it out, but I will take this message to Chief Carey.
And I think they've done and I really mean this, they've done a tremendous job in terms of getting up to speed, getting things open and using Zoom, which, as I said, I would never even heard of before this started. And they've really done a good job with it. There's been some glitches. Some of them I've told you about, I'm not going to get into, in terms of Zoom and bridge lines, which I don't like at all. That's where you're on the phone in a group. I think that they should just be eliminated. I don't think they work. I think that it's a really bad idea, but all right, to move on to jury trials. Okay. As a criminal defense lawyer, I am very, very concerned about starting up jury trials too soon. And we are. The pandemic, the numbers are just going through the roof. Okay. We're almost where we were in March and April. The governor, I read, just reopened some of the hospitals, for the overflow hospitals. And, why are we rushing to start jury trials when things are getting worse, not better? That's number one.
Can I answer that before you go on, just so I don't forget?
Yeah, please.
So it's a very difficult situation.
Right.
We have to balance, obviously, safety, and that's paramount. We don't want anyone to get sick and die, but we also have to worry about the defendant's constitutional right to a jury trial. And we have people who are languishing in jail waiting for their time. So we just have to figure out how to try to get started. That does not mean that if it's not going to work because of the COVID numbers or, for whatever reason, then we'll step back, take a look at what worked, what didn't work, and regroup.